Hello, everyone. Hello. Deb, thank you so much. That was such a great thing to say. I appreciate you very much. Hello, Becky. Crimes. Tennis Girl, thank you. Hello, everybody. Crime Coffee Crew, Becky, Crimes, Debbie, or Deb, sorry. I don't know if anybody else is live right now or not. Hello, Michael. Good evening. Welcome. So I figured what we'd do tonight is just go over some of the old motion hearings. Hey, Ian. Hello, my friend. How are you? Hello, Sky. I figured we'd go over some of the old motion hearings of Charlie, see if we can pinpoint. I know Daniel says it here. Don't know if it was said in a motion hearing. I swear I heard him say he had a waiver for Harvey and Donna, but I can't recall where, if it was in the first trial day or if it was in a motion hearing. So I figured we'd try to find the needle in a haystack and see if it was actually brought up or not. So I figured let's start with Daniel when he says he does on STS. And thank you, STS. Thank you, Joel, for this interview that you got with Daniel Rashbaum. It's queued up to when they start talking about the waivers. So we'll start there. Look at casual Rashi sitting in his booster seat for the interview. And Ian, oh my God, we were actually streaming Carl's stream while it was going on last night, and you had me laughing. Oh, and I knew as soon as Carl started laughing, I'm like, that's Ian. I guarantee it. I guarantee it was Ian. Let's make sure I got. Okay, we are going to jump into Rashi. Oh my God, this guy never goes away. He never goes away. His name suits him. He's a rash. He is absolutely a rash. Hello, Jane. Welcome, my friend. He never goes away. All right, let's start with Rash. Get right into it, and then we'll start going through Charlie's motions. Exactly. He's the rash you can't get rid of. There is no ointment for this man. None. A rash that spread through a family. Yep. There is no ointment for this man. There's no drug, no nothing you can take.
Do you really believe Charlie Adelson's story?
Again, I can't talk about Charlie's case, right? Out of respect to his current lawyer, and out of respect to him as a prior client. So I have to punt on that one.
I have to ask you about some conflicts here. You were Donna Adelson and I believe Harvey's attorney first. Charlie was with David Oscar Marcus, a pretty well-known criminal defense attorney. Do you fear some sort of conflict? And did Charlie and or Donna have to sign a waiver in order for you to represent her now? And did you ever stop representing her?
So let me kind of take things in turn, if you don't mind.
That was a lot of questions.
Yeah. So I did originally represent Harvey and Donna in a joint representation for years. When Charlie was arrested, that representation changed. And there was a conflict, and it was a waivable conflict that was waived by all parties. Okay. At that point in time, I represented Charlie Adelson and did not represent Donna or Harvey Adelson. Donna and Harvey Adelson at that point in time got their own lawyer. Okay. Now, You asked whether there's a conflict now, and the answer is yes. There is a conflict. It is a waivable conflict. So,
okay, so what he says with Charlie is that they all waived the conflict for him to represent Charlie. Now, is this waivable conflict? Is this waiver in writing? That he does not say. That he does not say. Hey, Mac, welcome back. Rashi's reputation in trash now. Well done, right? When was this? This is when he started to represent Donna for her trial, or for her when she was arrested. Hey, Jane, Mac. So, but he doesn't say he has anything signed. And we all know these waivers are useless anyway. They can be reneged at any time. Now, do we think Donna and Harvey are going to say they didn't sign something for Charlie so Charlie can get a new trial? Jesus Christ, this is a mess. This is just a bloody mess.
with ethics, lawyers, and waivers by all the relevant parties, that conflict has been waived. And as a result, I now no longer represent Charlie Adelson or Harvey Adelson, but only represent Donna Adelson. So just to be clear, when you say, were you fearful that there was a conflict? There is a conflict. It just happens to be a waivable conflict that has been waived by everyone.
So,
okay, so now he's getting into Donna, which doesn't matter right now for the Charlie situation, because go back to the Charlie one for a minute and he will say he's got written waivers, all 4. Yeah. For some reasons. Yeah, Becky, and that he's talking about for Donna, right? We know he says that he had written waivers for all 4 so he could represent Donna. But right now we're trying to pinpoint the minute where, or the time, sorry, where he says when he was representing Charlie, did he have written waivers from Donna and Harvey? Top Cat, yeah, Rash should still have the waivers on file. If he said, if he did what he said he did. This is a whopper, said Jansen, who has closely watched the case for years. This could be a new trial for Charlie, and they could be facing trial at the same time. Oh, I sure do hope so. If there's a new trial for Charlie, I hope it is at the same time, and the coffee crew were already working on a way to go to Tallahassee. Thrush bomb. Oh, I sure have missed you, Ian. Merch idea, Charlie waiver toilet paper. Yeah, because these waivers are, toilet paper has more use than these waivers, because at any minute they can just go poof and gone. I don't even understand why they exist, to be honest. I don't. It makes no sense to me. So then I found, this is a pretrial release denied for Charlie Adelson. This is when one of his first motions, let me share this. One of his first motions, because, oh God, of course the name is going to, help me out, guys. Hankinson, sorry. Hankinson was on the case as the judge. I guess if we think about it, the state had no obligations before they arrested Donna to verify a waiver. This new Charlie motion is all on Rashi. If I'm thinking properly, I'm no lawyer. Yeah, because honestly, it has really nothing to do with Donna's case. It's all pre-Charlie because Rash represented Harvey and Donna. And because of that, Charlie is saying that's why he couldn't call them as witnesses because it was a conflict. And his lawyer wouldn't be able to cross-examine them. Just like he's played that card for his mom's trial. This all is on Rash and his unethical dealings with his clients. Yep. It's so this is like when he was trying for pre-release. This is when if Charlie gets a new trial, Rashi should be disbarred and someone needs to sue him. We all should for mental stress. Honestly, I'm just saying, I know I'm joking, but I'm just saying. So in that interview, Rash says he has waivers from Harvey and Donna so he can represent C. Yes, he says he has them, but he doesn't say at that moment that they're written. But then he says when he goes to, like, I can go back to it, guys, if you want to hear more. Then he says when he's going to represent Donna, he's got 4 written documents so he could represent Donna. Hello, Jibs, and oh my God, Jibs, that is brilliant. And if you don't mind later on in the show, I will share it. It is hilarious. Yeah, but I'm just wondering because that's for Donna's trial that he says he has those. I'm trying to find out if he said prior to representing Donna, prior to Donna's arrest, as he started to represent Charlie, did he say he has written waivers from Harvey and Donna? That's the key. We need to find out before Charlie's trial, did he have written waivers from Harvey and Donna? He couldn't say no to his crime mummy, only think of the moldy. Yeah, moldy money. Absolutely. I'm honestly surprised that he is not under review now, but let me dig. I believe he is. I believe he is. Oh, I know, Top Cat. That's the thing, right? Because we've got one lawyer, 3 different clients, 2 that were up for murder. It's the key is defined. Did he say he had written waivers prior to going to trial with Charlie? The written waivers that he says he has are because he's going to represent Donna. We need to find the ones prior to Charlie. Yeah, same here, guys. So am I. Let me know how it goes. Hello, Hugh, my friend. Hello, crime crew. This case is getting even more strange every day. Absolutely. Deb says, I remember hearing him say that, named each he had waivers on. Yeah, and I know he said it to represent Donna, but that isn't any bearing on Charlie's trial. We need to find out if he said it for Charlie's trial. Armand, absolutely. Markels don't deserve this. No, they do not. They do not. Hello, Paul. Welcome back. They truly do not. And that's what I'm trying to find tonight is, did he say he had a signed written waiver from Donna and Harvey prior to going to trial for Charlie. Because that's Charlie's thing, is he wasn't able to call them as witnesses because it was a conflict of interest. Oh, Jibs. I was like, that's amazing. So we will play it because, and I noticed, Jibs, I believe you only need 6 more subscribers to hit 50. So please, everyone, go over to Jibs and Jabs, subscribes. Let's get Jibs to 50 tonight. That's our goal. 50 tonight, Jibs. And it's absurd to think that they won't be instantly retrievable. I could pull up an email or document from 10 years ago from my phone right now. Yep. And Paul, you're 100%. I said, I've been saying it. The waivers mean nothing. They're toilet paper. It has more use. Yeah. Mentor thinks the motion is useless. Carl thinks the case will be overturned. And mentor lawyer talks from both sides of his mouth. Everybody knows my opinion on the man. Do not like him. Plays tennis with Rashi. Now he's best friends. I'm sorry, Mac. It's nothing. It's just my opinion. I don't like the man. The problem is, even if he says he had waivers, he could be lying. Yeah, we need to see them in writing. Signatures. Hey, X. Did he say it's a judge right before the trial started for Charlie? Charlie's first trial day, maybe. Could be. Yay, I'm going to give the Sally Field speech. You like me. You really like me. I'm gonna try to get your link in for you, Jibs, so people can go over. The calling as witness is a separate issue from the pretrial waivers. They are using both issues in the appeal. Yeah. Yep, they are. But that is the major one, because Charlie's claiming he could not have witnesses to collaborate what he was saying. Oh. Paul, hi Deb, I subscribed to J&J. Thanks, Paul. I'm right there with you, X. He has a taste of what life is going to be like. Right? He has a taste. I know everybody's saying no, not going to happen. The only person that I find flipping on anybody is Charlie. And you know, at this point, I don't think it's too far off him flipping on his mom. I really don't. Not after the stunt that he pulled. So give me 1 sec. I gotta get I meant to pull this up earlier. Give me 1 sec, guys. I'm so sorry. But it's important to me, so I will take the minute to do it. What is this? I hope he is mad enough at Wendy to flip at least on her. I don't think the state would take any flipping unless he flipped on everybody. If Charlie doesn't now realize the bigger picture and flip on his family, he truly is a fool. I agree. Hello, welcome back. Hello, beautiful people. I'm back. Carl made a good point that the conflict inhibited Charlie from flipping on his mom or dad. Yep. I agree. Now that I simmered on down, I really think no blame goes to state nor judge regarding the possibility of new trial. See, and I still waver on that because I believe the state should have been more concerned about appeals. They should have been more concerned about that. They should have demanded to have this in the court files. They should have just covered every angle possible. Not only does he have a taste of prison life, but don't tell me he isn't incensed with Wendy. I agree. She's been walking. Top Cat says, yeah, but that is a stipulation I was talking about yesterday about witnesses. That does exist. Hey, Lynn, welcome. Thank you for posting that. Please, everyone, go over and subscribe to Jibs. Jibs is 6 subs away from 50. Let's show our love. Oh, we are so close to 3K. I haven't even looked today. I do, however, blame state and judge for Donna's trial being absolutely. Thank you for sustaining me in the wake of my, oh no. Oh, I am so sorry. The first arrest was made today. Oh, oh, wow. My heart goes out to you, If you give me your son's name, I'll put him on the ticker. Oh my goodness, We are praying for you, We are praying for you. And justice for you and your son. Well, all the evidence against Charlie does not really matter if Donna testifies, or better yet, testifies. I don't see how. Sorry, I'm still with for a minute. I don't see how Donna would have even helped Charlie at all. But I believe Charlie actually hates Wendy at this point. I do too, X. I absolutely do too. But the state had no idea who was representing Donna and no reason to ask. She was not in custody. I don't blame them for yesterday's motion. Donna's trial, different story. But I do believe, I swear I heard Rashbaum mention that he had a waiver from Donna and Harvey. Could be completely, you know what? We've had so many cases, so many ups, downs, so many twists and turns. It could be getting mixed up in my head. But you're right. If they did not know prior that Rashbaum represented Don and Harvey, then yeah, it's not on them. FYI, opening statement for Boone tomorrow starting at 9 a.m. Thank you, Deb. Laura, I subbed. Hello, everyone. Thank you, Laura. Thank you so much. My goal tonight is 100% get Jibs and Jabs to 50 subscribers. X says you're at 2.9, Rochelle. Nice, guys. Thank you all. Please feel free to criticize. I respect your opinion. Thank you, Sky, for putting that in there again. I appreciate you. Oh, no, I'm so sorry. I'm so sad, but happy you're for arrest. Absolutely. Currently at 29:05. 95 more to go, people. Okay. Sorry, guys. Chat's going a little fast. It's devastating. I think you guys were... Time says it's devastating. I thank you guys for the company. His name is Jordan Brown. Give me 1 second. I'm going to take the minute to fix this. Give me 1 second, please. Thank you guys for understanding. X, I think all the Adelsons will race to Georgia to cop a plea. They should all be arrested at this point and offer a deal to the first at the door. It would work, X. I agree with you. The Adelsons lack any form of morality and humanity. In the hood, we call them crash dummies. Justice for Dan. They are crash dummies. I am so glad we're here and you're here. Yep, crime's untangled. I will reach out to you as soon as we are done tonight. The state can't go around asking defense attorneys now, do you have a signed waiver or are you representing any of the witnesses? It's attorney's obligation. Yeah, I agree 100%. If I'm wrong and I'm just mixing up trials, then yeah, of course, none of this is on them. None. The Upperman is known for going after conflict issues, but hardly any are successful. Right? Let's hope. But with the Adelsons, I swear they've got horseshoes up their ass. Honestly, guys, I say arrest all four so they get independent counsel, whether you try them individually or not. I agree. 100% with you on that. %100% with you on that. Okay. So we'll go to this pretrial release here. I'm pretty sure it wasn't said because this is Hankerman. I know I'm saying his name wrong. Tennis girl says, but I always say state and judge totally at fault for Donna's trial. Judge should have asked Rashi at the first hearing. Yep, he should have demanded. First off, the state attorney's office should have said, absolutely not. This is a huge conflict. It's too messy. And if it was still something they were going to go at, then they should have demanded to have those written waivers on file. But again, they should have known that if Charlie's called, who's going to cross-examine him? This is on the state attorney more than Judge Everett, but the judge should have demanded to have the documents on file. I 100%. At the end of the day, even if Charlie gets a new trial, I still believe he will be convicted again, and any deal should force him to serve a mandatory 30 years before parole. Yep. I agree he'll be convicted again. I have no fear in that. This thing that makes me mad is the Markel's got to sit through this again because people drop the ball, and that makes me mad. But at the same time, they know if they do a Donna and Charlie trial, they can get a double conviction because they basically had Donna on trial in Charlie's trial. Carl seems to hold Upperman in pretty high esteem, and he definitely said he believes Charlie will get a new trial. Yeah, I agree with that. Dirtbags indeed, wanting disregard for human life. Couldn't have said it any better, We still don't know what Rashi said in chambers. And we did hear him on the hot mic, worried about his bar license. And no deal for Wendy. She did all this and lied under oath. No deal. Life in prison, that is. And to me, it's a race. Charlie deals or Wendy deals. But the state at this point has got so much egg on their face, they're going to take the first deal that takes them all. So who is it going to be? Charlie or Wendy? And apparently, if the judge had questioned Charlie in court, even via Zoom, that waiver would not have been revocable, or at least that's what I heard. I think that they said that it could be revoked at any time. Like Charlie could have waited till he was on that stand and revoked. Hugh says, such a waste of time and money only to retry again is what will happen. Yes, Charlie will get a new trial. I agree, Charlie will. Why is Wendy's lawyer tied into this with Offerman? Surely another conflict. I didn't realize that Laurel was tied into this. The first guy that they arrested is smiling on his mugshot photo. He's been charged with capital murder. I guess it has alluded to him the fact that this is a death penalty case. Oh my goodness. Would it be asking too much if I asked where this was? If so, please don't put it in there. Boy, Rashi was so happy to get off this case. He thought, cool, I'm going to take money and run. No consequences. Well, how's that going for you, Rashi? Right? It is very, very hard to get a conviction overturned, a very high bar for evidence required. But like Carl said, it's easier to get it thrown back to the court and let the court do the dirty work. We'll see soon enough. If it was done a certain way, it could be deemed irrevocable. Yeah, I think I think you're right, Tennis Girl. If they would have had him on video saying it, they would have had it in writing. Like two very concrete things. I think that, yes, at any time a waiver can be taken back. Well, I agree with that, but I think he would have had a harder time doing it if he would have been on video saying it. And they also had him. I honestly think Everett should have pulled him into court and did a proffer. Or sorry, a voyeur. Cringy, dingy Arkansas. Well, you got the coffee crew behind you. The only way out that I can think is if Rashi shows definite proof that this representation of Harvey and Donna was only a civil matter and not this case. Yeah. Because I don't think that would be... God, who knows? Who knows anymore? The day Charlie's conviction is thrown out, they need to arrest Wendy, Harvey, and then just say first one talks gets the deal. But it better not be a get out of jail free card, must do hard time. Yep, I agree. I'm sure Tim mentioned Ufferman and Laura, not Lauro, were on the petition court. Maybe similar name. Yeah. Laura is the girl that was at Donna's was talking for Ufferman. That's Laura. And Wendy's lawyer is Lauro. Two different people. One's a man, one's a female. Wendy likely has, hey Patricia, Wendy likely has access to all the law books that she can lay her hands on, so she is probably busy looking for a way out right now. Yeah. I moved my son from Chicago trying to escape the high levels of crime and ran right into the hornet's nest. Oh my God. Oh, my heart breaks for you. Rashi is the reason I don't like lawyers. Same here. All our heads are spinning with all the legal stuff. Yeah. Yeah. He says Laura. John Lauro is Wendy's. I'm beginning to think that they are never going to arrest Wendy. All parties need to stand before a jury of their peers. I agree. I agree. If you deal with the Adelsons, you need signature in blood, videotape, and fingerprints. Isn't that the truth? Yeah. Okay, let's listen to this one, see if we can find anything, and then we'll go, because then we'll go to oh God, I don't even know where I know. Like I said,
the court is in a unique position here because I sat through the other trial, which is what has been offered into evidence by the state. The entire trial and evidence from that trial, wire calls, the recording from the Dolce Vita meeting, the recording from the Matsuri meeting is additional evidence that has been reviewed and by the court today. Also, there's some iCloud texts and depositions that has been presented to the court today. So I have reviewed all the evidence, so I am in a position to make a ruling. The court finds that based on the evidence provided by the state, that the state does meet the standard of proof evident or presumption great that the defendant has committed the three charged crimes. Not only is there direct evidence the court finds from the Dolce Vita video and statements made therein, but there's also a wealth of circumstantial evidence against the defendant. Even if a court subsequently finds that there was only circumstantial evidence, I find that the evidence presented by the state certainly rebuts every reasonable hypothesis of innocence. So I find that the first part of the test is met and proof evident or presumption great.
I've got a friend called Nick Laurel who is related to the past owner of the ship, the Archie Laurel, and we say both these names like Lou as in loud and Roe as in row at Crime and Coffee. Yeah, but he's talking about the female. Okay, let me just go to that hearing. Donna's motion hearing. Hold on. Donna's, sorry. Donna. Adelson. Jury selection die. I'm just going to pull this up because you're going to see the Laura that they're talking about. Let me just find it. Stopping in to spread some love to Rochelle, lovely community, hoping all are well and happy. Hey, Thumper, my friend, welcome. Yeah, I know you were getting the name. I know, Laura, you were getting the name from Tim Jansen, but he actually was talking about Laura, and I'm gonna pull it up. I love you, my friend. Top rated mod, in my opinion. Laurel Niles. Thank you, Armand. See if I got hello one. Welcome. They got that video chopped down so much. I'm just trying to find. Surviving the Survivor. Motion. I don't know why they've chopped that video up so much. Just watching chat too as I'm, yeah. Laura is Offerman's law partner. And that's who Tim Jansen's talking about. But everybody, because they hear the name, it sounds like Wendy's lawyer. But no, Tim Jansen's talking about so I'm just trying to get that. Everybody's chopped it up so much, it's unreal. For some reason, you put in Donna Adelson now, and everything that comes up is Wendy. The reason I'm telling you is because Laura and Laurel are said in completely different ways. Laurel is said like the start of loud. No, I 100% get it, guys. I 100% get it. I'm just saying that when Tim Jansen says it, people thought he was talking about Wendy's lawyer, and he wasn't. He was talking about the girl that works with Offerman. So I'm just trying to bring up that video just so, because Offerman is not working with Wendy's lawyer. Hello, Wolfie, welcome. Hi, everyone. How is your day? Thank you, Deb H. I'm quietly lurking or doing rewatch. My father would have said, fly low and don't scrape your belly on the runway. Can't take the fighting out there in the streets. Oh, it's getting worse. It's getting worse, eh, Thumper? It's getting worse. I don't know if this is going to show us any. They've got it chopped up. They've got it chopped up so much.
Welcome back to Court TV Live, along with Julie Janae and Ted Rollins. We'll head back to the Carly Gregg trial in Mississippi in just a minute, but we have some breaking news out of the state of Florida in the case concerning Donna Adelson.
They've been dealing with an issue all morning, an issue about Charlie Adelson, the son who was convicted in the death of Dan Markel already last year. He was going to be transferred to testify against his mother, but there was a waiver he needed to sign because his attorney is also his mother's current attorney. Let's go in.
Whoopi, Carl doesn't say Charlie will win an appeal. Carl's saying that if it's sent back to the court, Charlie has a very good chance of winning a retrial or getting a retrial. But Carl doesn't say he will win his appeal because Carl thinks it's going to go to retrial part before it gets heard to the appeal part. But Carl's been right, so I don't go against him, but I hope he's wrong. And I'm sure he hopes he's wrong too.
Into the courtroom and see how it unfolds.
We continue forward.
Yes, Judge. May I approach the lectern?
You may.
So, Judge, with the surprise issues of the last couple of days, I have asked for my prior client's waiver again. And with the change of circumstances.
Damn it. This clip is behind that woman. Thumper, I haven't heard the impact that Charlie testifying might negate the attempt to call Rash conflicted. Charlie said all Donna could have. Charlie had his fair day in court. No, Charlie is putting the complaint forward with Ufferman that there was a conflict between Rashbaum and Harvey and Donna, and that's why he could not call them as witnesses. None of us are sure what we mean, Wolfie, anymore with the Adelsons. So Charlie is saying ineffective counsel, and he's also claiming that he could not call his mom or his dad as a witness to collaborate his story because of the conflict with Rashbaum. It's a mess, Thumper. It's a freaking bloody mess. Tim Jansen's believe it will be sent back to Judge Everett and state may not respond, and judge will have no choice but to overturn the conviction. Tim knows his stuff big time and he's local. Yep. Agree. I see. Guys, if we don't think he's going to get a retrial, we're got our heads in the sand like an ostrich. Like, Wolfie, it is a hot mess. It is ridiculous. The Markels deserve more. Dan Markel deserves more. It's just disgusting. It is absolutely disgusting. I have a feeling that Rashi will get away with it. No discipline. Probably a good chance that go play nice now. The man needs to hide. He needs to hide and never show his face again because he's a disgusting human being. This case has gotten so much BS going on. Yep. I remember they said they'd plead the fifth, so that's why they wouldn't testify. Yep. Because if the state was to call them, they had to give them the same immunity as what Donna got. But if the defense had to call them, there was no immunity. So they said they would plead the fifth. Hello, Bumble, my friend. Welcome. Rash is laughing all the way to the bank. Lawyers patting him on the back. I would think lawyers are trying to stay as clear as him away from him. I'm waiting to hear when he is kicked out of his firm. That might be the only repercussions he gets. But if he thinks that Donna's not suing and Charlie's not suing, somebody in the Adelsons is suing him. I think if Charlie's conviction overturned because of Rashi's conflict, Rashi will be in heap of trouble. Yep. And the state is going to have a lot of heat on them to arrest all of them. And it's what they should do. It's what they should have done from the beginning. No. Oh, sorry. Wolfie says at Tennis Girl, are you saying that Charlie could just go free? No. No, not go free. Wolfie, just get conviction overturned and he'll be back in Leon County Jail. Yep. I've never seen a case get so screwed up just when you think it's going good. Boom. Yep. How did that one at a time go for you? How did the one on the time go for you, Jack Campbell? I have a feeling the bar is definitely looking harder now. I think I agree with that. If Charlie's gets overturned, I agree with that. And they should. They definitely should. And will the state care about the heat? No, I have no faith that they will do anything different, and that upsets me. I agree. They should, and they should care about the heat. They should have cared when Donna's trial went poof. They should have cared. They don't care. They got egg on their face. Well, now they got freaking egg salad on their face. I guess at least I'm happy Sarah Boone was denied snacks. It was so funny to hear the judge and motion for snacks. No, she'll get what every other inmate gets. Yeah, at least there's some good news today. Oh my God. The Adels could sue the state attorney's office. How? I'm not sure about that, Irene. I'm sure they could sue Daniel Rashbaum, but I can't see how they can sue the state attorney's office. Can you explain that to me? Egg salad. Yep, now they got the whole damn egg salad on their face. I tell you.
He has decided not to give it. So let me be clear. I have a waiver in the past. It's from December 12th, December 13th, and an independent lawyer spoke to him as well, although did not get a signature.
See, but this doesn't stand for what we're looking for, because this is a waiver for Donna's trial. We need to find one that says he had a waiver from Donna and Harvey for Charlie's trial. That's what we need. Charlie's trial, not... Oh, sorry, I meant the Markels. Okay, thank you. Yes, I think civilly, they won't, though. They won't. If anything, right now, they won't. I don't think you can sue state attorneys. Hi, Thumper. So glad she was denied her snacks and candy. Hi, Deb. Hi, everyone. Hey, Leah. Okay, so this is not going to be... Let's go to... This one here, that's not going to be it either. Because I know it's with Judge Everett. Everything's going to be when Judge Everett was... I was wondering, Irene, and are drinking Modelo again? If so, please have another. Gosh. I honestly, I'm really doubting myself. I don't think there is something that was brought up about it. Let's see if I can... I honestly don't think there is. Wolfie, probably not, but I would be looking to empty some pockets, but that's just me. These lawyers and the state only care if it hits their wallets. Thumper says, so Rashi represented Don and Harvey, who had no criminal charges at the time. So Rashi is a civil law lawyer at the time. Maybe there's less conflict than Rashi did. Criminal law for Charlie. And I would have thought so. But for some reason, they're saying, the YouTube lawyers out there are saying that he would have been in the same position where about cross-examining or examining Donna or Harvey. It would have been a conflict. So Charlie wasn't able to have them as witnesses, which I don't think would have helped him at all anyway, but who am I? Right on. And that's why I meant them to have a claim against Rashi's malpractice insurance. That'll get them. Even asking for these snacks and candies was just Sarah's trying to assert her non-existent status as a high-profile suspect, that she's proper nutter. You're right. I like it when you use the word nutter. I just want Wendy to be arrested at this point. I just want her in jail, but that's just wishful thinking. Same here, Wolfie. I can't stand the thought of that evil person, trying to be nice with my words, evil person walking free, enjoying the fresh air, enjoying the sunshine, living her best life, because that is exactly what she's doing, and laughing. She's laughing at everybody, just like she did on the stand. The state won't arrest me. I just can't stand it. I was disappointed that Cheetos left off the snack request list. Hey, Janes. Hugh, how is this going to play out? Will all the screw-ups here It's looking pretty messy. Will anybody be held responsible for the latest mess? Doubt it. I highly doubt it, Hugh. That's a start at tennis. I'd be riding Rashi's ass over this. Yep. You take a 48-hour break in these cases and you're drowning in deep end of the pool of the issues. Jeez Louise. It's insane. James, and good to see you. And yes, but his entire firm would be upset with the insurance claim. Looks real bad all over. It's just, and don't forget the harvest moon. I've already taken my bowl out and released everything. Wendy is a confidant, and Wendy is as confident as Jodi Arias was. I would say even more. Honestly, Hugh, I would say even more. Because the state has been so open about it. One at a time, stay tuned, one at a time. So they just keep expanding her clock more and more and more, her calendar days more and more and more. Stupidest move I've ever seen. Sarah Boone should demand Reese's peanut butter cups for Halloween or she will refuse to shower. I couldn't even get the gall of her with that motion. And if I thought before something was fishy with Owens, today even proved it. He tried to sneak so much stuff. This guy is and he won't go to the microphone. And you know what I was saying? He doesn't want the public to hear him be a slimy sleazeball. We can't hold him against his words because we can't hear him. Giant bright full moon tonight, and yes, Wendy gets the prize over Jodi Arias. You're right. You were right too. We're all right. She's a evil person. Now I want Cheetos. Okay, so we'll go to this one. I just don't know. This is day 1. So hold on. This is day 1. I honestly don't know if anybody has an idea of where we might find Rashbaum being asked by Everett about. See, and I don't think there is. I'm thinking of Donna's trial. I'm getting them mixed up. I don't think there is. Wendy is despicable, allowing her family to be jailed, allowing her own mother to be jailed at her age, and continuing to deny all knowledge of her own plot. You couldn't make this shit up. No, she don't give a shit. She threw them all. She threw her mom under the bus. She threw her brother under the bus. Only person she hasn't named is Harvey. But she did it right in her interview. I thought it was a February hearing, but someone else said December. Yeah. I'm in my head. Now I'm in my head. That's exactly what Owens is doing, talking just loud enough for the court. He doesn't want this to go to trial and is bombarding the court with 300 pages of BS. That's ridiculous. It's absurd. And we can't hold him to his words because we can't damn well hear him. And he knows it. So he is that slime bag that I think he is. Pretrial hearing or Charlie. Yeah, pretrial hearing for Charlie. It's got to be in a pretrial hearing, and it's got to be when Everett took over as the judge. But it's definitely got to be in a pretrial hearing or a motion hearing because that was where it would be brought up. And it's going to probably be, and that's why I said I can't find it. I can't find the one where they're talking about Donna and Harvey taking the fifth. So if any one of the coffee crew can find that, could you please let me know? Could you email me the link? Because I can't seem to find it on YouTube. Might have been, not sure what you're saying, Laura, sorry. And just remember, guys, I got a time delay from YouTube over to StreamYard. So sometimes if they arrest the other two, they can get their own lawyers, and the state could try them one by one with a year or some back-to-back. Mess cleaned up. Bumble, I agree with you. Creator Uncivil says he was reached out by Billy Lane to represent Boone, and he declined. Pardon me, guys. Sorry. What? I don't think it would have been before Everett, because it would have been because they're saying that Everett never asked about it. Yeah. Wow, that would have been something to see Kurt try this case. Yeah. Yeah. I just think there's something fishy with Mr. Owens. I don't like him. He just comes across as somebody that's I don't know how he came on this case, where he lives, and where he's got to travel to get to Orange County. It's all just very suspicious to me. But we'll get to here and see if we see anything here.
Court is now in session. The Honorable Judge.
Now Donna and Harvey on the witness list was before Charlie's trial started, maybe like a week or two. Yeah, that's what I mean. And it's that motion hearing or that hearing that I need to try to find, but I can't seem to find it. And Laura's case started before Everett. Yes. Yes, it did. I understand the case started before Everett, but the trial was Everett, and there was only I think there was only one motion hearing, might have been two motion hearings before Everett took it over.
Stephen Everett now presiding.
Everyone can be seated. We have the court TV staff here.
There she is in the back.
Just to think, we're going to see this effer in court again.
Test man, did you already do that?
Yes.
Okay. I believe that's just the small addition that is already sitting on the witness microphone here. Okay. And
I believe she did, Wolfie, when she made the phone call. And then when she got off the phone, what did she say? Oh, that's a relief that she was surprised. What? Why would you say that? And then where she said like her family was very angry at Dan, but I don't recall anything being asked about a waiver in the hearing. I just don't think it was asked by judge. I agree now. I think I'm getting all the times that judge asked Rashi for Donna's trial. Jib says, are you looking for a clip of Everett almost issuing a warrant for Donna? That's the hearing I'm looking for, Jibs. That's the hearing I'm looking for. Just to think we could possibly see this damn guy in court again. And we thought he was being cocky this one. Imagine if he gets a retrial. She has absolutely no moral compass. No. She doesn't even have a soul. That woman don't even have a soul. It's horrible. Yeah, I saw the clip on Pretty Lies and Alibis, but I'm looking for the whole hearing. I've spent most half the day looking for that darn hearing, and it's just nowhere to be found. Wendy says, or Hugh says, Wendy's saying she's relieved at the interview about her mom seemingly surprised upon hearing the news of the shooting. Unbelievable. I agree. That was one time right there. She threw her mom under the bus. She knew she was being recorded. She knew it was being videoed. And then when she kept saying, well, my family, they have reason to be very mad at Dan. Like, don't tell me this freaking woman didn't have this plan from the beginning. What sickens me is that people like Wendy often do well. She'll get hers. Karma's a bitch, guys. Anybody that has experienced karma, they know it's a bitch. Somehow, some way, Wendy Adelson is gonna get hers. And honestly, I tell the state attorney's office in Tallahassee, pull on your big boy pants and your big girl pants and get the effing job done. Enough's enough. The Markels have been through enough. I looked up day one of Charlie's trial. They had a sidebar first thing. Maybe waiver was talked about then. X is lurking. We see you, X. We're looking for a needle in a haystack is basically what we're doing, Coffee Crew. But again, honestly, it doesn't really matter because the fact is it can be waived at any point. He's got Offerman. Offerman's going to talk him through this. He's a great appellate lawyer. Wendy threw everyone under the bus except the TV repair geek. And don't forget the liquor guy at ABC Liquor. He was just really curious about her very blue eyes. Jesus. This is ridiculous. So before I go any further, because this is my goal tonight, my major goal tonight is jibs and jabs. Why is it doing this? Just want to see. Folks, we need 5 more subscribers to get Jibs to 50 subscribers. We can do it. We can do it. Can one of the mods please put Jibs's link into the chat? Let's get those 5 subscribers for Jibs. That's our goal tonight. I'm okay if you don't push like if you can only push one button tonight, if you can only push one button, let it be the subscription button for Jibs and Jabs. Yeah, she did. She loves her eyes. We will get back into this and let's go. We can get Jibs 5 more subscribers, guys. We can do it.
On the jury box, where is the microphone? If you can show me.
Thank you, Sky Troop. I appreciate you for doing that. We got it.
Yes, ma'am.
Do it.
The platinum on the red. Here.
Okay.
And then one more.
Thank you, Willie.
And this
I
has already
appreciate
been
you.
tested with the,
With the iPhone.
yes,
Yes. It was in this one.
very well. All right, those microphone additions will be fun. For any still photography that's to take place, this camera does not click or make noise, correct? Go ahead. All right, it needs to be completely silent if any still photography is to take place. Once again, no pictures of the jurors, no video of the jurors. Their identities are to remain unknown until the trial has been concluded. The parties have anything that they wish to bring to the court's attention before we get going?
Judge, briefly, maybe we go sidebar.
You may.
Okay, Deb, thanks. This is the one. This is the sidebar. Lurking as usual. How are you doing, Elizabeth? Patricia, how is your daughter doing? It's like a darn ant. I wish we could just stomp on them. Trisha says she's still in intensive care as she got a serious infection, but as the bowel was operated on, it's to be expected. I spent the day with her today at Crime and Coffee Crew. Thank you for asking. Oh, our prayers still keep going out to you and your daughter, Patricia. Finances, money laundering, all that crap. And Deb, how are you doing after your surgery? Recovering all right? Three away, Jibs. 3 away. We can do it, guys. Let's get Jibs and Jabs to 50 subs tonight. 3 away, Jibs. Does anything with that trial happen one time, tennis girl? Oh. We can do it. We can get Jibs. 3 more subs, guys. We can do it. Let's show the community how we help grow each and every one of us. Just tennis girl, there's still a motion to hear that will be at 9, then reopening. Yeah, that's the Richardson hearing that they're going to be clearing up. So just so everybody knows, Crime and Coffee will be streaming Sarah Boone tomorrow and all the trials. If I have to work, Crimes Untangled is going to take over my stream. I will be a guest on my own stream, and we can go from there. Oh, me, gee. I thought I heard that and hoping not. Yeah, the Richardson hearing for all those, for that 119 that they were trying to bring in, that they handed over to them at 9 o'clock this morning on a thumb drive. Ridiculous. So maybe noon or later or Monday. If I was the judge, I would have said Monday, but I guess the state has expert witnesses that they have to work in. Thank you so much. I appreciate you so much. Thank you. Can you imagine having to see this? Oh, thank you so much. SK, welcome. Thank you. Hey, B Rabbit, my friend, how are you? Let's check on Jibs here. Let's see what we've got going on. Absolutely, Armand. We'll have a better picture when the state responds to Ufferman's motion. I checked today. Nothing yet. I wonder why it's not letting me. Let me go home. Let me try this. Reboot. Have you subbed at Jibs and Jabs at B Rabbit, trying to get him to 50? We can do it. We can get Jibs to 50 tonight. Jibs, let us know. Oh, Marie, you are so sweet. Thank you for the super sticker. I appreciate you so much, Marie. This community, guys, is absolutely amazing. We're not in it for just the channel. I don't want that. I want a community spread out as far as we can spread out. And Marie, thank you so much for your support. Do you know anything about the timing for that Armand fence? Tennis Girl says, wow, nice, super. At Marie. Thank you so much, Marie. They will have to get Rash's affidavit on why there is no conflict. And Patricia, I know it's so cute. Yippee. Armand, Tennis Girl, no, I don't. I've been watching I was wondering why Charlie wasn't moving. I'm like, why is he not moving? Oh. Jibs, let us know when you get that 50. Like, I did not see. Well, that's going to be tough since Judge Everett already tossed Rashi because of the conflict. So I don't know. Doesn't look good. It doesn't. Thank you again for doing that, B-Rabbit. We are so close to getting Jibs to 50. We can do it, guys.
Before we bring the jurors in and get started this morning, I just wanted to also provide 2 additional points to the members. It came to my attention yesterday that someone was.
Christine, I just subbed. I was number 49. 1 away, guys. Thank you so much, Christine. I appreciate you. Evening all. I was Jib's 50th. Woohoo! We did it. We did it. 50. You like me. You really like me. Thank you, everyone. We did it, guys. As a community, we raised another creator up as a community. I am so grateful for every single one of you guys. I'm so excited. Now we have True Wife Crimey. True Crime Wifey. One of these days I will say it right the first time. Now we need to get True to 50. Oh, Jibs, I'm so excited for you. Please keep me grounded, everyone. Thank you. Oh, I'm so excited. I am so excited for you, Jibs. This is what this is all about. I think True is over 50. I thought we did that a while back. I don't think she's there yet. I think she's just shy of it. I'll double check. Monarch says, Rochelle, I forgot to thank you for adding Maddie to your banner. Oh, you don't have to thank me. Thank you for bringing it to my attention. I appreciate that. Jib says, break out the tequila and a suitcase for the party. Deb, you're welcome, Jibs. You are very talented and deserve it. Absolutely. True wifey crimey. Yeah, Armand. Why I say it wrong every time. B Rabbit, I was thinking at Jibs, if I could sub more than once, I would. Absolutely. Jane says jibs and jabs. Yep. Oh, okay. True has 62. Okay, so we did do it. Thank you, Tennis Girl. Why I didn't think we did. Oh, I'm so excited. I'm so happy for you, Jibs. So happy. Sarah gives sleepover parties. Sarah gives sleepover party a real bad name. She sure does. I'm one of your OGs, Jibs and Jabs. Oh, I'm so excited we did that. And, you know, Jibs is amazing. Jibs is amazing. All right, let's see if we hear anything here. I don't think we do.
Zoom in on what was happening at the defense table. Whether it be the state or the defense, no one is to be doing any zooming in of what is being communicated between counsel or the parties, or in some way trying to decipher what is taking place with them. Also, whenever the jurors are in the building, the media members are not to engage them again. This trial or create an issue that's going to interfere with the trial itself actually taking place. Does anyone have any questions concerning this? Yes, ma'am.
Your Honor, just a quick question. I set up my camera this morning in the hallway. Whenever I saw someone that wasn't legal counsel, I turned it away. Is that okay, or would you prefer me to not do things like that?
You can have cameras in the hallways. Really, the issue again is broadcasting anything that would otherwise identify a potential juror. I don't know if all of you know who the jurors are. Again, whether it be traditional media or new media, the identities of the jurors until the trial is over is not to be released, either photographic, video form.
Jane says, hey, Rochelle, there's more dirt on SB when you're ready. Lots of write-ups in jail. Is that on her? Is that in the court dockets, Jane? Jib says, I really appreciate everyone. You're very kind. I hope to continue to be part of this community. I don't know how I found this community, but I'm glad I did. I'm so glad you did too, Jibs. And I'm so happy for you. I am so, so happy for you. And you will always be a part of this community. I think the more positive that we can be here and the more positive that we can spread out is just what we need to keep light on all victims. And that's the major thing. I'd like to see SB write up. So would I. SB stapled her jail pants not once but twice. Where did you get this, Jane? If you can direct me into the right place, I will bring it up. Monarch says, congratulations, Jibs. Marie says, Jibs and Jabs is very creative and he is going to grow with creativity. Absolutely. Jibs and Jabs, all right, man. Don't get above yourself. Just keeping you grounded, my friend. It's under visitation reports. So under the jail, I'll send you. Thank you. Thank you, Jane. Jibs says thank you. You're special, Jibs. That's why I said that what you created, I didn't want to take away right away because I knew that that was going to be amazing on your channel. And thank you for sharing it with me right away because I couldn't stop laughing. Leah loved the Jeopardy video. I did too. I loved it. Now you all know why I was laughing so hard that night. When you watch that Jeopardy video, you will understand why I was laughing so hard. Yes, we sure can. Yep, Jibs gave me permission. Absolutely. Jibs gave me permission. So this is Jibs's new creation. It makes, I'm laughing already. All right, here we go, guys. Oh, let me get this out of the way.
Our first contestant is Caddy Cook Lady. Tell us a little about yourself.
I'm Caddy Cook Lady. When I started my channel, it was for the purpose of sipping wine and for letting you know who I know. By the way, I'm friends with Ruth Markel, just in case I haven't said that on my channel. If you say anything that is contradicting to my view, I will get triggered and send you to detention. But first, please contribute to my coffee.
Okay, thank you, Caddy. Our second contestant is Patty Snitches. Tell us a little about yourself.
I'm Patty Snitches on the bitches. Don't do anything in front of me, bitch, because I'll snitch anytime, any place, anywhere.
I can attest to that.
Okay. That's great, Patty. Thank you. Our third contestant behind the screen is Beachy Fiction. Can you tell us a little about yourself?
I'm Beachy Fiction. I was the first to report on the Markel case, and I have a lot of haters.
Okay. Right, lots of haters. Ain't that something? Thank you for that, Beachy. Oh, wow. Okay, I didn't see your $40 friend of Ruth Markel t-shirt. Thank you, Caddy Cook Lady. Anyway, these are the 3 YouTuber contestants on tonight's game. The categories are
Alcoholic drinks, The Circle of Trust, crime, Dan Markel murder, hurricanes,
alcoholic drinks, circle of trust, crime, Dan Markel murder, hurricane. Beachy Fiction, we will start with your choice of category.
Dan Markel murder for 400.
Name the investigator who interviewed Dan Markel's ex-wife.
Who is Beachy Fiction? That is right, haters. I'm the original OG. You best kiss the ring.
Sorry, Beachy Fiction, but that is not the correct answer.
You are wrong. You are a hater too, just like all the other circus freaks that don't recognize that I'm the OG investigator. And I have all the informants from Miami to Austin, Texas, because I am Beachy Fiction.
Okay, nice try. Thank you, Beachy. I see how the question might be confusing. I will be more specific with our questions. Patty, you are next. For 400, who was the Tallahassee homicide police investigator who interviewed Dan Markel's ex-wife?
Who is? Detective Craig Isom.
Brown noser.
Beachy is my friend and she is always right.
Why don't you kiss my ass?
I didn't do anything. I'm the victim. I don't know why you are attacking me. The OG investigator of the Dan Markel case.
Bitch, are you crazy?
Ladies! Patty, stop!
Beachy, did you do something different to your hair?
Oh. Now you all understand why I was laughing. Oh. Now you understand why I was laughing so hard the other night. Oh. Oh. Oh God. The possibilities are endless with this. Exactly. Oh my goodness. Oh. Oh, it's just so brilliant. My cheeks are so sore right now. Too funny. Altruistic baby. Sorry. Welcome. I like the lady in the middle though. That's a good idea. I'm stealing the idea. Oh. Oh my God. I don't know, but I unhid it. Brady snitches for president. Yeah. Oh, hello, Barb. I'm sorry. Jibs, I have more, but it's hard to download, so I cut it short. Oh, you should make it a series, Jibs. I think YouTube doesn't like so many emojis. I think it likes maybe mostly 5. Leah says, Rochelle, can you please play Jibs and Jabs Jeopardy video? I just did, Leah. I just did. Did you miss it? Wolfie, this is Jibs and Jabs, the one you said you subscribed to. I hit it. Laugh out loud. I'm scared of YouTube. I'd pay to see the reaction to it. That's horrible to say, but I totally would. So, Christina, so would I. And I love where Jibs puts in the circus freak because that's me. They've called me a circus freak. Why do I think Kook Lady is standing on a litter box? Oh, altruistic baby, play it again. If you guys want it played again, I'll play it again. I can't get enough. Wait just a minute. At Christine Hawkins. Oh yeah, Jibs and Jet. What about Family Feud? Oh, could we have the inner circle family and then the circus freak ones? That would be great. You steal them. FF called me a circus freak. Well, probably Kook Lady too, but I'm a circus freak. But that's okay. I accept it. I accept it. Oh. What did Max say? Yeah. Oh, Jibs, that would be great. Family Feud. Have the inner circle, like the what do they call them? The cool kids. And then have us circus freaks on the other side. Oh, that'd be brilliant. Oh. And then who could be the host? Carl Steinbeck. Carl Steinbeck could be the host of Family Feud. We live in an upside down world. A normal person is the circus freak these days. Yep. I am cool. Kook kids. Hello, Angela. Welcome. I'm sitting here eating peanuts from Five Guys, so it won't be a circus freak side. Oh, Judge Everett. Yep. Judge Everett or Carl Steinbeck. Oh God, that'd be brilliant. All right. So Judge E, he's not boring. No, he is not boring. All right, we're going to play Jibbs's one more time because I've been asked to play it one more time. Oh God, Jibbs, this is brilliant. Anyone new, please go over to Jibs and Jabs, like, share, subscribe. Oh. Okay. Here we go. Oh, God. Thank you, Sky. I just know it's coming at me.
Our first contestant is Caddy Cook Lady. Tell us a little about yourself.
I'm Caddy Cook Lady. When I started my channel, it was for the purpose of sipping wine and for letting you know who I know. By the way, I'm friends with Ruth Markel, just in case I haven't said that on my channel. If you say anything that is contradicting my view, I will get triggered and send you to detention. But first, please contribute to my coffee.
Okay. Thank you, Caddy. Our second contestant is Patty Snitches. Tell us a little about yourself.
I'm Patty Snitches on the bitches. Don't do anything in front of me, bitch, because I'll snitch anytime, any place, anywhere.
I can attest to that.
Okay. That's great, Patty. Thank you. Our third contestant behind the screen is Beachy Fiction. Can you tell us a little about yourself?
I'm Beachy Fiction. I was the first to report on the Markel case, and I have a lot of haters.
Okay. Right, lots of haters. Ain't that something? Thank you for that, Beachy. Oh, wow. Okay, I didn't see your $40 friend of Ruth Markel t-shirt. Thank you, Caddy Cook Lady. Anyway, these are the 3 YouTuber contestants on tonight's game. The categories are alcoholic drinks, circle of trust, crime, Dan Markel murder, hurricane. Beachy Fiction, we will start with your choice of category.
Dan Markel murder for 400.
Name the investigator who interviewed Dan Markel's ex-wife.
Who is Beachy Fiction? That is right, haters. I'm the original OG. You best kiss the ring.
Sorry, Beachy Fiction, but that is not the correct answer.
You are wrong. You are a hater too, just like all the other circus freaks that don't recognize that I'm the OG investigator. And I have all the informants from Miami to Austin, Texas, because I am Beachy Fiction.
Okay, nice try. Thank you, Beachy. I see how the question might be confusing. I will be more specific with our questions. Patty, you are next. For 400, who was the Tallahassee homicide police investigator who interviewed Dan Markel's ex-wife?
Who is? Detective Craig Isom.
Thank you, Becky.
Brown noser.
Beachy is my friend and she is always right.
Why don't You kiss my ass.
I didn't do anything. I'm the victim. I don't know why you are attacking me. The OG investigator of the Dan Markel case.
Bitch, are you crazy?
Ladies! Patty, stop!
Oh, this is so brilliant.
Beachy, did you do something different to your hair?
Oh, it never gets old. That's the best part. It never gets old. Oh my God, guys. Oh, it's the hair. Oh, Jibs, it's amazing. I enjoy it so much. Oh. And I'm so glad we got you to 50. Oh, Kook Lady is a grifter. Oh, he does pop up in there. He does pop up. Oh, Jibs, how long did that take you to do? Can't even imagine how you do it. Oh, God, that is so funny. Oh, my cheeks are so sore. That's right, bitches. Oh, God. That is quality, seriously, at Jibs and Jab. Absolutely, Patricia. It's great. It is just so good. Oh, my God. Leah says, I subscribe to you. Jibs makes me laugh so hard. Great job. Please do more. Absolutely, Leah. Thank you. Alex Morris was counting the money he was going to make, but he got bounced. Yep, he was. Jibs is at 52 right now. Bravo, guys. Oh, that is so awesome. Up and onwards, Jibs. Up and onwards. I know we have someone else. Who else have we been trying to promote on here? Alex Morris was, oh yeah. Monarchs. I don't think Patty will. I know she's received the clip. I just hope Patty's not offended, but this is hilarious. I don't think she will. I think she's going to laugh. Yeah, Patty was nice to them and they snubbed her 100%. I bet the video gets lots of views. I bet you too. Was that their voices? If so, how did you get them to say the things? They were the voices. They were the voices. Rochelle, do you want the site that reported on Sarah's jailbait hair? Absolutely. Hello, Cookie. Welcome. Hi, Rochelle and everyone in chat. Late, but glad to catch you live. Welcome, Cookie. Check your email, Rochelle. I will. Oh, I texted that before you played it. Okay, thanks, Leah. Max says we're the voices AI. Oh my goodness, guys, says you can clip audio. Jibs, well done, my friend. Well done. Okay, that's the link. Thanks, Deb. Let me just pull this up. Oh, I can't pull it up there. What am I doing? Silly Willy. Hold on, pause. All this. Okay, so I'm going to put this here. What's this? Okay, we can't get rid of that. What's this? Get rid of that one. Share screen. Hold on. Okay, so 1 second. I'm going to check my email first before I go any further, because Jane sent me an email with it. Oh my gosh, my cheeks are still sore. Oh, Jibs, that is so funny. Oh, Jane, you sent me 2 emails. Oh, okay. These are. Okay, so this is from. Okay, thanks, Jane. This is from the same girl. Okay, so we'll just. Oh, Sarah Boone Staples. 2 cents. She is hilarious. Sarah Boone Staples and yelling issues in her inmates' behavior report. That's hilarious. Barb 17. Hope you were with PP earlier. I think those creators are ridiculous. So disappointed with. Yeah, I am disappointed with them too. Oh. I stand with Patty on this one, guys. I stand with Patty on this one. There's no need for this abuse that she's taking whatsoever. She is great at Tanika. All right, let's listen to Tanika.
I'm lovelies. How are you? Am I the only one who needs a Sarah palette cleanser? Probably not. Let's make fun of Sarah, because then I don't have to cry.
How long is their video? Oh, it's only 13 minutes.
We've got her latest IMS report.
Me too.
This is starting from 9/11, a bunch of breakfast refusals through 9/17, 9/19, then 9/22. Officer Shanique Beckford. Somehow Sarah's gotten a hold of more staples. Let's delve in, shall we? While conducting a visual inspection, inmate Boone Sarah was observed with staples in the seams of her pants. Her pants were immediately replaced.
Sorry, guys. Armand says, isn't PP covering the burn pile trial? Are they trolling? Yes, and yes. Tennis Girl is a mod over there, and she's doing a wonderful job keeping them out. Tennis Girl, she is covering Armand fans. Hope to see you there, and thought I had. The trolls are minimal, though. Yeah. OG was in there the other day. I saw that, but I also saw Tennis Girl take care of that business.
Placed with an appropriately fitted size, medium, to which she began to complain about her appearance in the uniform she'd been given. This is now the second documented time inmate Boone has been observed altering her blues issued uniform in this way. She knew it was against the rules the first time because it was swapped out then too. I asked her where she was getting the staples from. Inmate Boone replied, I got them from the books that the chaplains give me and from the books on the book cart. Y'all keep thinking I have some kind of special access to these stuff. Inmate Boone was advised, with this being her second offense in altering her issued uniform, any further infractions will result in a disciplinary report. Inmate Boone stated that she wanted a smaller uniform pant because the one she was issued doesn't fit properly. I reminded her the uniform is meant to simply fit and not reveal her figure. I informed her I would be placing a negative in her inmate notebook to document the repeated and intentional violations of OCCD's rules and regulations. She proceeded to threaten me by stating she planned to file a motion with my name in it. So make that negative really good. Yikes. 9:22, 11:21 a.m., same officer. With the arrival of the lunch meal, I called for the bottom tier of B dorm to come get their meals in bunk order. Inmate Boone knows she does not receive a special diet, yet when she came to the table where the lunch trays were placed, assertively and with what I perceived as an attitude, shoved her inmate ID close to my face, stating, "Sarah Boone, bunk 4, I do not get a diet tray." Based on her demeanor, inmate seemed to still have feelings over me replacing her self-modified blues uniform pants. Negative earned. This officer has some.
Hi, JJ. Tennis Girl says, okay. Oh, okay. Well, it's pretty slow moving, laugh out loud, but would love to have you in the chat, Armand Fence. We are super fun, and Patty explains stuff. Absolutely. Patty's great. Sky says, the full moon is spectacular out my window. That's awesome. This explains why she wanted a skirt so badly. She's very focused on her appearance, which doesn't look like she ever was in the outside world. If anyone wants a fun daytime channel, please sub at Patty's Playhouse. Absolutely. Thank you for doing that, Tennis Girl. Patty's Playhouse. I took the liberty of sharing Patty's channel at Crime and Coffee because you are so nice, and I assumed you wouldn't mind. Absolutely. I do not mind at all. Do not mind. I am a huge supporter of the justice community and people that talk straight and give it straight, and that's what Patty does. And you know what, guys? Patty took a phone call from me when I was so small, and I said, would you please do me a favor? Would you please come on my channel? She did not once him or ha. She said, absolutely, I will help you out. And that is what she did. Was I horribly nervous? Absolutely. Did I stumble over my words? Yeah, I did. But she was so gracious, and I appreciate her for that. The Justice League. Yep. And I don't know if you see it at Crime and Coffee, but I share your channel on her stream every day. I do, and I appreciate that. Thank you. Yeah, Patty's Playhouse. Love her. Deb, if you have the link for this channel that I'm viewing, can you put it in? I would greatly appreciate that. Cookie, KCL is an insult to my intellect, and FF and TSP trying to force us to support her. I have subbed and will all I can for coffee and crime. Oh, thank you so much, Cookie. Let me hold on. I'll make it smaller so I can see here. Tanika 2 cents. I thought she's asking for her tiny pink shorts to wear with the matching cartoon hoodie. So cute. Listen, I said this is not a channel. This is a community, and I'm going to stick to that. And we support each other in here. We support other channels that have a similar view on community, and that's exactly what Patty does. And she helped me. So I've got that girl's back. I've got her back the whole way.
Some trouble with spelling. I didn't point them all out. You guys can see them. But she doesn't need a special tray. There's no reason for her to go and tell the officer and stick the badge in her face that she doesn't need a special tray. Like, girl, have several seats. We have some more breakfast refusals.
Absolutely.
And then on the 3rd of October, she gets the Bible devotional, not spelled right, Daily Bread, In Touch, The Word for You Today. And this, I think, is maybe address book. I don't know what that means, though. Like the yellow pages? It may be something else. It's spelled ADRRES. Anyway, that was on the 3rd, 11:35 a.m. Then we have, Nalimar Ortiz Torres, 10/5/24 at 4:18 p.m. Today, inmate Boone was scheduled for a visit with her legal counsel. At approximately 15:19, while passing by the briefing room, I heard a loud noise followed by shouting. I encountered Corporal Pagan in the hallway and inquired about the source of the commotion. Corporal Pagan informed me that the noise originated from the briefing room. We proceeded to open the swing door and checked on the situation. Attorney James Owens acknowledged that he was the one who had yelled and expressed his apologies. I informed both Mr. Owens and inmate Boone that their interaction, regardless of its nature, was disruptive. Mr. Owens offered another apology and then exited the room. So this is the one you guys are telling me about on the 5th. So remember on the 4th, that's when they were in court, right? Because 7, 6, 5. Yeah, so this is the Saturday. On the 4th, that Friday, they were in court. And that is when the judge questioned Owens on being behind in his dues. And Mr. Beck said, they are paid up or whatever. And it got cleared. Then they meet on the 5th. They have this, he's yelling at her about something. I'm wondering if it's yelling about the plea deal. Because then when we see Sarah on Monday, the 7th, the beginning of jury selection, that was before the storm. She on the record rejects the plea deal. So I think that's where it all started. Like he was hoping she would, and that's why he got it on the record to CYA, because we all know when she loses, she's going to come after Owens for ineffective assistance of counsel, even though he did what 8 people before him wouldn't do. Inmate Boone, okay, this is on the 6th, 3/16, so this is the day before trial. 3:20 or 3:16, it was logged at 3:21. Inmate Boone was set for an interview with Mr. Owens today at 11 a.m. or 1100 hours in the briefing room. I informed my chain of command about the events that occurred yesterday. Refer to the behavior note entered. We just did, girl. Lieutenant C. Warbriton instructed me to interview inmate S. Boone to confirm that she had no concerns regarding her safety. Corporal T. Pagan and I proceeded to B dorm, where we conducted the interview with inmate S. Boone in the atrium. She expressed that she did not feel threatened and agreed to meet with Mr. Owens. I recorded the interview using the supervisor's cell phone and uploaded the video for the FDCA2 folder for documentation purposes. Wait, they have an atrium? That actually sounds kind of nice. Upon Mr. Owens' arrival at FTC, Corporal T. Pagan and I met him in the visitors.
Sorry, guys. Armand says, I don't subbed KCL or FF, got a YouTube recommendation of some sort. Short she did was very strange. Something about eagles come from shells, dig at PP, I think. I'm not sure if it was a dig, but I know which one you're talking about. Sarah was mad over the snacks. She scolded Owens. Yes, she did. I'm just so confused why the feuding started. Maybe I don't want to know. Just came out of nowhere. KCL had an issue with Patty for some reason. And then the whole dragon necklace, which was disgusting on KCL to do. And then the way she was treating her subscribers, which are also Katie and my subscribers. And Patty just didn't like it. And they went hard on Patty. They are still going hard on Patty. I liked Katie Kool-Lady in the beginning So did I, except for the whole Tallahassee thing that threw me right off. She didn't hear the ruling because she was telling the blonde cleavage cam girl to scram. Yeah, the Barker's beauties were there today. I think it started around the time Patty wrote letter to the bar. Yes. Yep. At Jane, and I'm glad I'm not the only one who saw how showing off her girls inappropriate. Oh, it was. Has anybody in chat have opinions in Melody's trial? To me, it looks like Chad and Amanda knew. And as for that judge, worst ever, he seemed against the prosecution. Never seen a judge behave like this one. There's no way. Melody is guilty. There is just no way in my mind that she did it alone. There's just no, I just don't understand it. It was around that time exactly, but why have a feud over it? I don't know. I think the breaking point, the absolute breaking point, JJ, was the owl necklace. An owl necklace was made and delivered to Patty and asked for Patty to give to two people in Tallahassee, two streamers, content creators, and one of the persons, well, I'm just going to name her, KCL, decided on a drunken rant on the channel to call it garbage and throw it in the garbage. And it was made, and it was beautiful, and I'd love to get my hands on one. Sarah interacts with them like they're besties, and they're indulging her. Oh, did you see when all three of them were at the table there? And it was like she was at the cool kid lunch table. Like, whose girls? Oh, the Barker girls. I call them the Barker girls. Owen's assistants. They're like the Barbies. The lawyers let her borrow their own suits. Did you see? She really is full of cosplay. Yeah. Tennis girl, the blonde on Sarah's team. Yeah, she was dressed inappropriately. Melody is 100% guilty. Who the accomplice is a mystery. Yep. I think she's guilty, but I haven't seen the evidence. Oh, and JJ, Dawn, that's what I call what our Sky Troop says likes. Who is she showing them off? I think to the TV. I think to the cameras. A blonde paralegal on Sarah Boone's legal team. Yeah. I gotta watch Sarah's hearing now. The Candy Club, Mean Girls Club. MLS's video made it sound like Patty should stay in her lane. It's something that did not need to be made publicly. It was to shame her, in my opinion. I agree. I haven't liked that guy from the beginning, though. Never have. The blonde at Sarah's table, she just had a real tight tank. Yes, she did. And there it is. No, we're talking two different things now. Cleavage Cam is the blonde on Sarah Boone's team, and the one that threw the owl necklace in the garbage is KCL. Two things there. We covered two. The level of privilege Sarah is being given is, yeah, it's disgusting. Got it. Though you were talking about, yeah, no, two different things at the same time. Altruistic baby. TSB has made some posts from his mom's basement attacking Patty, totally uncalled for, and Roderick is unstable and unemployed and a wee bit of a loser. I'm telling you, that video is disgusting. Disgusting. Monarch says, I watched KCL's live and she was upset because Debbie Martin and Irene supposedly were bad-mouthing her on ML. They were talking about her drinking and going off the... I was like, this is not the KCL I have come to know. I was shocked. ML needs to stop telling women creators how to behave and act. Yeah, he needs to mind his own business, that guy. He needs to mind his own business. The guy goes, you know what? I'm not going to hide behind this. The guy goes to meet Sarah Boone twice. What does he do right after? He comes back and makes a parody, makes a joke out of it. The only reason he said he was a lawyer and he was concerned and all this, the only reason he went to see her was for content and to make fun of her. That's an evil human being. Like, I don't like Sarah Boone. But you just go because you're a lawyer and you can get your way in just to make fun of her on your channel. Then the next day she was given the owl gift and she took it as a sign. Yeah. Watched the beginning of the hearing on Fangirl in her corner, smiled broadly and waved at Sarah, and Sarah snubbed her. Are you serious? I'd like to see that. We can do it. I know we were supposed to be turning Charlie, but we went off the rails. But that's what we do here. Casey yelled at me on her channel, but didn't use my name. Isn't that silly? Why would you yell at someone? She's pretty easy to make fun of. Sarah, yeah. So I think we're gone off Charlie. So hold on. I want to get this lady's channel. Hold on. I want to get her.
Hello, how are you? All right, where have I been?
One second. I'm just going to get her channel link, guys. And I'm going to paste it here. That is Tanika 2 cents. Please like, share, subscribe. I appreciate you guys for doing that. How'd we go from Charlie? Now we're going back to Sarah Boone. I'm going to have to change that. I'm going to have to change the thumbnail. Katie was definitely kooky, only watched one video, and it was like SNL parody of an OnlyFans promo for our seniors, for over seniors. It got awkward real quick. It sure did. It sure did. I don't know why what happened in Tallahassee sent her off, but no, the only thing about this hearing is it's very hard to hear. Owens, I wasn't going to do it because of the fact Owens was just annoying. I'm just going to get it to where Sarah comes in. There we go. It was a sad moment. Honestly, it was a sad moment. It's nothing. There's nothing that can be more said than that. Then it's, to have people that she's so happy. She's in a yellow shirt today. To have people that have such a following and to keep the word out there, the voice out there for Justice for Dan, because they are 100% Justice for Dan channels. And to keep that word going and then to surround it in such negativity is just very sad to me. It's very sad. I enjoy mocking perps, but not other channels. That said, some content creators think we want to watch what they had for lunch today. Yeah, like I said, I'm just saying how sad it is that people with such a large voice have to shroud it in negativity. And that's sad to me. Yellow is not a good color on us super pale chicks. You can tell when she's angry though, she gets really blotchy. So do I. Yeah, she thinks she's a voice for women. Oh. I think they should put her in softer colors. I agree. Yep. Want me, Claw? She looks like Mickey Rourke in Some Angels. Yeah, they should have put her in some softer colors. Oh, B-Rabbit, it's funny to watch her, though. I think she thinks she's second chair. Yeah, she is.
William J. for the state.
Sarah Boone.
Ma'am, good morning. Can you state your full name and date for the record for me? Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, State, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing.
He's talking to the bald guy, guys.
I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now. So give us a moment. You did not.
Oh, they didn't do their paperwork.
Madam Clerk has advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday.
JJ, I am located between Trenton and Kingston. The young lady who just spoke to SB is the one she snubbed earlier. Leah says, I must have missed where they denied her getting snacks. Can anybody? It's at the very end. Yeah, east. I wish. It means I would be in a warmer location, Hack. Oh, that for sure. Irene had a friend that did everything to ugly herself at work, even work what she says, wear Coke bottle lenses, glasses, and did nothing to deter. That's sad. Seems like YouTube doesn't like the word bitch anymore.
So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come?
Christine, it was a Nickelodeon game show.
Makes it very difficult to prepare for opening statements when I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box. But
I understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay. Well, then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson is going to take a minute. This afternoon, I guess we start at 10:30 or 11, and that's going to spill until probably late afternoon before we actually get a jury pick. Can we just agree on Friday morning starting opening statements? That gives her time, him time, me time.
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 tops.
Okay.
And then we've got each jurors, pause and pretorial.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do.
Oh, I can't believe Owens blasted that Brian Boone relocated with his son. What a jerk. And not only that, Irene, that she is actually still fighting for her alimony. She still thinks she should be getting alimony. There's an open case on it. I couldn't believe it. SB liked watching boys at the mall. She never had a life. Yeah. I love how Attorney Jay is calm and doesn't have his hands around Owen. On the other hand, just can't even say words tonight, like he is doing sign language. We have a jury, yo. Oh.
Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it and make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions and limits.
Alimony paid in honey buns and soap packs. There is no going back for Sarah. No plea deals. No nothing. No, she's stupid. But she honestly has an open case for her alimony. Can you imagine?
Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with the motion in limine. Totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you?
Yeah, it's done, Matt.
Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Ms. Owens?
Yeah, they have the Richards hearing first thing in the morning and then opening statements. They have 6 jurors and 8 alternates, was named at end of day, and jury instructions were read to them. Sarah thinks she can continue to control her ex-husband through the court. She's off her rocker. She is. You would think at MAC 2466, but there is another flipping motion. Opening statement Friday morning, depending on how long that motion hearing is going to be in the morning. I was so glad to be done with Sarah Boone.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion limiting regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
You're right, Patricia. The judge is continually livid. She's doing the June hair flip. While they're on break and we can talk without interrupting. On the Discord, we have a sub-channel set up for Florida road trip. Anybody that is interested in getting together, we have enough people, we're going to rent a house for Donna trial, Charlie trial, or the Donna Charlie trial. However it works out, we're just getting some names of people that are interested in going, and then we will be making that sub-channel private, invitation only once we get names in there. And so there's myself, Shiraz, Tennis Girl, myself, Shiraz, Tennis Girl, Deb. I know I'm forgetting somebody. Who am I forgetting already? Oh, JJ. JJ, you have to join on Discord, though. And we will get everybody. I'll still know you're going, JJ, if you don't have Discord. But we will be, once we get a few names in there, we will be closing it up, locking it up, and it would just be invite only. It's on Discord. Give me a minute and I will try to get the link in there for you. But I just want to say that. Also in the description, guys, Genuinely Gina. She is one of our subscribers on the channel. If you scroll in the description, you're going to see two Amazon links. She publishes she's got her own children's books, and she's got a journal there. So I want to help her out. So her links are in description. Okay, let's fast forward and see if Boob Girl walks over to SB. Thank you, Deb. I appreciate you. Okay, let's go back. It should get us closer to it. Mac, look at here. I know we're probably a year out, but it's always good to start planning something like this. Because as soon as they announce anything, we'll have to get on it because yes, tennis girl, all at Patricia Burns, love you. And you, friend, are very entertaining. Chatter, always love seeing you in the chats. Absolutely. Great addition to any community, Patricia is. Okay, they were airborne for a second there. Pretty bad what we... No, the blog is Wendy. Oh. She's like, I wonder if I can take these staples back.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state.
I bet.
Sarah Boone. Charlie Adelson for Sarah Boone. Mr. Beckett.
Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Well, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Judge, was it emailed to us?
Sure.
I didn't know.
Madam Clerk's providing you a printed copy, sir.
Thank you, man.
Bless you.
He doesn't. So sad.
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
She doesn't like him crowding her space. Yeah, she's not drunk anymore. She's still an a-hole. I agree, Mac.
I'm reviewing that.
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from the.
There once was a kind judge named Cray who wisely told Sarah to pray. She demanded a dress but was still a hot mess. Then the judge said that biatch is cray cray. That's so good. He gets very close and touches her too. It's weird. Yep. But SB doesn't have personal space boundaries either. Nope, she doesn't.
For several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017, Rudin versus State, 182
Hello,
Southern
Miss Todd.
3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time are we talking about for Dyer? Are we talking about open?
Armand, and I'm afraid of that. She's going to claim the police interview was false because she was so ashamed of being a battered spouse, playing into her victim mentality, and believe all women claim. I am afraid that's what she's going to play, and it's going to piss a lot of people on the outside off. I was just going to say the same thing. Mac, good night, my friend. Thank you for joining us.
Statement. At what time are we talking about?
During the testimony or trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 7 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide.
Oh, Jane, you're so sweet. Patricia Burns is the Limerick OG. I'm not going to pull a peachy friction. Oh, I'm a little short this week. Can you loan me a moldy stack till Friday? Also, that George was of a worse kind and she was a guardian angel trying to redeem him, right? I guarantee that's what she's playing, Armand. The number of people who loved ones who are also DV victims won't be fooled. Yeah. And please, everyone, if you're just coming in tonight, please keep your prayers and everything with Im and her son Jordan through the criminals will be put away and Im and her son Jordan Brown will get the justice they deserve. Yeah. And Owens will say the Torres family are violent. Yeah. Patricia says that, Jane, it's good to have a poetic equal. No one owns words, my friend, and you are very good at it. I'd like to have a book up for both of you. That would be awesome. I would line up for that book.
Citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the bracket's victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just I understand and I'm clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone. And in this case, we all know that has to come from someone.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
Your Honor, and then the only other thing that beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes. Just my overall understanding is that the motions and the orders that the court has applied to trial and the organization or the flow of the evidence at trial.
Oh, man.
Be presented before certain witnesses can testify. It has nothing to do with or dire nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone.
Sorry, guys. I was just looking up Jordan Brown. Wow. There once were some dim Latin kings who liked robbing and shooting up things. They didn't get far before shooting their car, and now Luis Rivera sings. And then there was Tennis Girl said. Yep, absolutely. And the Markels. Yep. I'm son. That was just last month that she lost him. August 29th. If you're still lurking, if you're still out there, my heart goes out to you. I just read your son's obituary while we're watching this. My heart goes out to you.
Over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal based on Young v. State 369 Southern 3rd 12.
Crimes, I would link it, but I'm not going to, because their real names are in it and a lot of names of their family members, so I don't want to link it on YouTube. But it's very easy to find. Owens has no idea what a Richardson hearing is. The judge has to school him. Yep. I pray for comfort and strength for your through this difficult time. Let us be there for you if you need someone. You do not walk alone. Thank you so much, Deb, for that. Owen's body language is telling. Yeah, it's to lose, like, same with Ruth, right? No matter how old your child is, to lose a child, breaks your heart. Yeah, I would link it, guys, but unfortunately, not unfortunately, there's a lot of names and family names, and I just don't feel that needs to be put on YouTube.
43, I am required to conduct a Richardson hearing. Court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
The 81 pages are not at issue.
they were given Sarah Boone from the admin health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night.
Oh, use a damn mic.
So we provided those to the state as soon as we were aware that we had not given them.
And what do the 119 pages evidence?
Their medical records from the hospital relating to Sarah Boone over a period of time.
Oh.
That's going to be whittled down.
JJ Dawn says, I make glass beads for children with cancer. The program is called Beads of Courage. JJ, do you have a website? That is a worthy cause at JJ Dawn. If you have somewhere where someone can go, email me the website or the link, and I will make sure it stays in the description, and I will make sure it gets put in chat. That is amazing. Not for that. I send my beads to the organization. Okay. Well, I can, if you can send me the link to the organization's page, or I'm putting up some other beads soon. Okay. How can we help you with that?
Now, depending on her testimony and whether or not you can cooperate.
This is why I wasn't going to do this, because you can hardly hear.
I need more specifics than that.
Thanks, JJ.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
Judge is still talking to you, asshole.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
He doesn't, Sky. He doesn't even know this guy. Is she writing a new manga carta? Thanks. It's a labor of love. It absolutely is, and it's a great cause, and anything I can do to help. Oh, could you imagine how he goes home at night? He's probably like, oh.
Medical records of Sarah Boone that we've gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break and let me find out.
Supposedly she did. That's why they're starting to claim the domestic violence syndrome. Sarah is busy acting important for her fans. How long before she gets like Wade Wilson's got wives? How long before she gets the Sarah Boone husbands? I hope she's writing poetry. What was I gonna say? So guys, remember how I said Wade Wilson and it's called Fundly? So it's not GoFundMe. It's actually Fundly, Fundly. That's where people are donating to him. She's writing snack reviews. JJ says, I have to sign off. Love everyone. Night, JJ. Sometime we're going to get together for a coffee, JJ. We will miss you, JJ. Miss Sky says, see you again, JJ. I didn't even know there was a program called Fundly. Sarah's just writing instructions for Owens. She probably knows what a Richardson hearing is. I'm waving.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood.
Texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3.
Be right back.
Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor. The state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those?
Yes.
The DAC and the narrative are on?
That's what's going to be offered into evidence at this point in time.
We'll work on that right now.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Sorry to be obtuse, but did she get, I think you're meaning lawyer then. Yes, that's Owens. Owens is the one that stepped in, and then he brought his crew with him. His posse, I guess you'd call him. What the heck is Sarah doing? I'd love to know what Owens gave her as a busy work. Hangman. They're playing Hangman.
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs.
Yep, has to be because she wasn't entitled. Correct me if I'm wrong, guys, but I don't think he's classed as a public defender. He said he answered an ad, please. I don't believe it. No, I believe a lawyer that visited her, reached out to him. It will be amazing to get jury reaction on YouTube tomorrow. How are we going to get a jury's reaction? Owen says Boone will pay her back. He's a private lawyer. I believe that all these motions and that 500 page of Advent Health is all her idea, and Judge knows it. I won't be surprised. She will tell the lawyers what questions to ask. Oh, Armand, I agree. How can she possibly pay? She can't. She can't. Unless they all think she's going to get out and then she's going to do some major book deal and, start to think she's going to go around. Sarah has to catch up on her fan mail, people. Wolfie, we'd all like to know. Yep. Wolfie, she can't. He is hoping to cash in on a book and movie deal. Probably. Wouldn't doubt it, Sky. Or the new one, I guess it's called Funly, because it was on a YouTuber that follows Wade Wilson put it up, and it's Fundly. I guess they're not as strict about bank accounts and things like that. Yeah. Unless she's found not guilty, then she can. Owens has a company of lawyers that they do pro bono work. I think he owns it or is like a CEO or something, but it is a business. Yep, it is a business.
Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities asking for records, and we're just waiting on response.
Too late, jackass.
The objection sustained.
Okay, Irene, thank you. Thank you.
Moving to 6. Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Ms. Boone.
Second chair.
Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records
Dear God.
is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect.
Thanks, Patricia.
A middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through.
Oh, Patricia, you can say that again. She makes Nurse Ratched look like an angel. Absolutely. I think it was a big tactic to try to delay it more. That's what I think. No, Mr. J is not getting enough, not being paid enough. But most, some inmates, I understand that's a lot. Some inmates make quite a secret deal that they're, they're in there for life or whatever. They make a deal where their kiosk is always full. They're not getting as much, obviously, as the person that writes the book, but.
Alcohol abuse, yes. Spirits, not wine. Last used 22320, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
Okay.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit into evidence. I intend on potentially the doctors, the experts, Dr. Warner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't know. I'll wait. I will not have.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we don't take.
Owens and Sarah's equal. I'm like, well, asshole department.
Okay. State with.
That was the only purpose.
Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
I agree, Ms.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit.
Jane, yes, Joel has been reporting already. Oh, so Jane, you're meaning he's going to give us a breakdown of what he's seeing the reactions are. Oh, that's great. I'd like that idea. Thank you, Jane. We'll definitely check out SDS tomorrow. Been popping in and out of their content. I love Professor Joe. Man, Maeve is good if already got some of those dismissed jurors. Wonder how soon that girl will find out the internet is calling her boob girl. Oh.
Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 7.
Sorry, guys, I'm going to ask a question. Are you going to, I'm just wondering, do I do a live for Sarah Boone trial, or would you guys rather be watching it on STS or any of those? Let me know. Pro Joe is excellent. Joel told her she's going to host the show, and Armand Fence, I bet she covers them things tomorrow. Because if you guys are going to, like, to me, it's okay. Like, STS, we can review it in the evening. I just want to know from you guys, so either I set it up or I don't. Yeah, I'd say a lot of people are going to be watching Burn Pile of the recap and review at night with you, Rochelle. Just saying, okay. Do a Boone stream. Wait till the court finds out it has a cleavage cam. Because let's do a commentary tomorrow night after that trial. I would rather watch directly from Law and Crime. Like chatting with you all at night. Okay. That's fine by me. I'll be watching while I'm at work, just so I know what the hell's going on. Evening is cool for recap. Okay, guys. Because honestly, like, I'm just looking at it this way. We've got the Burn Pile going, which is an incredibly interesting case. It's got me captivated. Sarah Boone is starting, but you've got yes, and we can FF the boring stuff and just make fun of the shit that happens. Insomniacs for Rochelle. Yeah, I'm just wondering, guys, because honestly, like, I've got such a busy week, unfortunately. Oh my God, Melody's lawyer's a crackhead. Honestly, I have to wonder where they got their education from. I was looking for a channel called The Burn Pile. Forgot about Melody. Yeah. Patty is doing the Burn Pile trial. I've been waiting so long for this trial. There's no way I don't watch this like a cat staring at a fish tank tomorrow. Yeah. Like, I would have streamed it from Law and Crime, but at the same time, there's all the other channels covering it. We can just do a night review. But I have to say, I'm not crazy about the prosecutor. I agree with you there, Tennis Girl. He is so desperate and aggressive for no reason. I don't like it at all. Good night, Becky. Thank you for joining us. Right, I can't stop watching Boone. No, and it's the burn pile trial is like a couple of Chapo episodes of Dallas. Absolutely. Remember when her lawyer told the judge she doesn't have any kind of blood sugar? No wonder she needs snacks. There's so many trials going on right now. That's why I was wondering. Yeah. That's gonna be my problem because usually I watch the burn pile with Patty while I'm at work. Yeah, so, okay, well.
17, the jail calls involving defendant and third parties. State anything else to add other than your written?
Crimes Untangled. What I'll do is I'll bring you on with me at night and you can stream it to your channel. So you'll still get people streaming through you. We'll do it that way. I still want you to be able to get the help you need with your channel. Oh, and yeah, and that case is going on too. Got it. I didn't realize I paused it there. Burn pile is slow moving for sure, and the boyfriend was not as gripping as I thought it would be. This screen freeze is the Sarah Boone OnlyFans look. What the heck is she writing? Would just love to know. Sarah makes the funniest rabbit faces. When I'm at work meetings, I make shopping lists. Thank you, Crimes. Yeah, so I will bring you on, Crimes, so then you can stream it to your channel at night, and that should help you still. I think Judge Cray is full steam ahead. I predict opening statements before lunch. But I guess Patty just makes me laugh, and anything she streams is entertaining to me. She does. Great screenshot. She is writing, it was not intentional 100 times. Patty does have a lot of her own sidebars. Yeah. Oh, I do not want to imagine that. Not at all. Okay, let's get back.
Written objection. Response.
The defendant is not intending to introduce the jail form.
Okay, the objection is sustained. 18, prior criminal history of Jorge Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record in Sarah that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, maybe Massachusetts. We're not referring to those. We're all referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries, photographs, officer visibility.
Justice Warrior Sarah has 4 years to come up with a better defense. What has she been doing? Incorrect answers only, please. Oh, that's brilliant. Sky Troop says hoarding cheese slices. Yeah, she did just gulp a yawn. Yep.
Observing injuries on her. That's the nature of this. So I don't think there is going to be anything about prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what that was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, when Dr. Brennan will testify, I assume Dr. Crumble will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. Her family can't help her. She has an group. The state attorney dropped 3 of the charges. 3 separate times, Jorge Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down.
Oh, I agree, Jane.
Dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr.
Thanks, Sky.
what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response.
Let's be used to refresh the office.
She has the diet of a 13-year-old. Of course, her blood sugar is dropped. Saint Sarah is so happy to be known as a syndrome. Of course, calligraphy and creative writing at Crime and Coffee Crew. I'll know it when I see it, Judge, but for now, I don't know. He doesn't know nothing. This guy is a whack job. He is wackadoodle. Lawyer wackadoodle.
Memory, if need be, during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one. Okay. Then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further? Because we kind of addressed this as well with number 19. Anything further? Argument state. Anything further? Argument.
This guy says at Crime Coffee Crew, Irene, I'll know it when I see it. Comment is a t-shirt. That is a good one. Oh, sorry guys. I just took my medication and it's really kicking my butt. I heard a creator call him a Southern gentleman and Mr. J seems New York. Come on, Owens is a shyster. Absolutely. Wackadoodle lawyer and loony boony suitcase Sarah. Kyrick takes the lead again, keeping it moving. Yep. You tell me and we'll both know. Yep. That's another one.
Okay. I'm going to overrule the objection as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he
I don't see Joel in the courtroom. No, Joel is sitting to the corner. I guess it's the media section. I remember the COE said the other day that it might change when trial starts, but as of right now, so it's off to the corner. I think Boob Girl also advised Sarah to keep her hands down earlier in the week because Boone gets those hands flying. She sure does. Jibs and Jab says, sorry, Rochelle, I couldn't find the video, but I did find the date of October 20th when it was stipulated that Donna would not be called. Thank you, Jibs. I will look that up. Thank you so much. I appreciate you for that. He's in the corner. When the jury hears that she felt her life was in danger from the overact of 2 fingers sticking out of a suitcase, it will be over. Now I must stare at Sarah's hand. She must love not wearing handcuffs in public. All right, Miss Sky. Yeah. I really noticed it in the interrogation. She's all hands. Yeah. The COE on STS, because people were asking in their chat where Joel was, and she explained, because Joel texted it to her, that he was in the corner in the press section, and they don't know if that's going to change for the trial.
Ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone is not in that force.
What does the non-payment of alimony have to do with what's happening in a family case?
Well, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached. That her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony.
Oh my God, he's not biased about alimony. Jane says, of course, Sarah bashed those 2 deadly fingers with the baseball bat, so maybe not that deadly. No, she's going to say he was giving her the finger and it was threatening. Jane noticed the Boone said specifically his little fingers, and now defense is saying it was his threatening hand. Oh, these guys.
Supposed to pay $1,000 a month for a number of years, and he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
So if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Can you all approach just for a moment?
Common Coffee Crew. It looks like we're going to have to go back to using the studio slow chat again. The option is gone from phone currently. Next show, I will open the studio as well. Okay, thank you, sir. Trigger warning. I believe she will demean and shame George Littlefingers and makes up some BS about him. It will be a lot like Jodi Arias, I think. I agree. On October 5th, the state asked for Donna to be held in contempt. Okay. I'm writing these down, Jibs. Thank you. Just checking something because I think we might have just got a drop from. I'm just going to check. I think we might just got a drop from the. Jibs, that's hilarious. No, this is not. Okay, no, that's not it. Let's go here. Here we go. Here we go, guys. I knew it just dropped. The appeal. We got it, guys. It just dropped. Charlie's thing just dropped. So we're going to pause Sarah Boone for a second. Because, oh my goodness. Sorry, guys. I'm in a lot of pain right now, but this is important. No, this is the information. This is the, sorry, I got to get rid of this banner for a minute. This is what they filed. District Court of Appeal. I'm going to make it as big as I can for you guys. Charlie Adelson. Motion to relinquish jurisdiction to the trial court. You know what? Here, I'm going to get myself right out of the screen. I'm sure you guys can still hear me. Yeah, well, it's not leaked anymore. It's just dropped. I've been keeping my eye on it. The appellant, Charles Adelson. Hi, Gamma. Hi, everybody. I was trying to find out what happened in Delphi today. Jury was sworn in. They discussed the sketch of the man on the bridge. I want to go tomorrow, but heard they are already lining up. Oh, no. Okay. Guys, I'm not even going to read chat for a minute. I'm just going to, let's go through this. An appellant, I'm not ignoring you guys. I just want you to know that. Appellant Charles Adelson, by and through undersigned counsel, moves the court to relinquish jurisdiction in this case to the trial court and alleges appellant Adelson is appealing his conviction following a jury trial for murder, conspiracy to commit murder, and solicitation to murder. Appellant Adelson was sentenced to life in prison. Appellant Adelson is one of several persons charged with the murder of Dan Markel. Prior to Appellant Adelson's trial, 3 other people were convicted of the murder of Mr. Markel: Sigfredo Garcia, Luis Rivera, and Catherine Meg Benoit. After Appellant Adelson's trial, but before his sentencing, another alleged co-conspirator, Donna Adelson, Appellant Adelson's mother, was indicted and arrested for murder. Number 3, at his trial, Adelson was represented by attorney Daniel Rashbaum, Esquire. After Adelson's sentencing, Mr. Rashbaum appeared as counsel of record for Donna Adelson in her case. Oh, man. On September 11, 2024, the state issued a subpoena on Adelson for him to be a state witness at Donna Adelson's upcoming trial. Shortly thereafter, on September 17th, Mr. Rashbaum withdrew from Donna Adelson's case after the trial court, the Honorable Stephen Everett, questioned him about the conflict of interest that existed due to his current representation of Donna Adelson and his previous reputation of Adelson, who, and then there was a footnote, Judge Everett also presided over Appellant Adelson's trial, who was now a witness in Donna Adelson's trial. Then on October 7, 2024, the trial court disqualified Donna Adelson's other defense lawyers from her case on the basis of Mr. Rashbaum's conflict of interests. The withdrawal of attorney Daniel Rashbaum became necessary when he engaged in a conflicted representation, falling short of the ethical obligations for members of the Florida Bar. Upon further consideration of the September 17, 2024 record and the in-camera proceedings with attorneys Daniel Rashbaum and Robert A. Morris, a sufficient ethical wall was not established. Thus, the conflict of interest involving privileged information or communication has been imputed by Robert A. Morris. Additionally, this case is rife with the potential for the same conflict as to Adam Commissar. See Kolker, freaking Kolker, and a bunch of case law. Unimputing a conflict seems as implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back in the tube. Oh my goodness, they used friggin' Everett's words. Florida are regulating the Florida Bar. case law impose on all Florida attorneys an ethical responsibility to refrain from engaging in conduct intended to disrupt a tribunal and conduct which is prejudicial to the administration of justice. While the defendant retains a presumptive right under the Sixth Amendment to her counsel of choice, the right is not absolute. Wow, they're saying everything. The presumptive right under the Sixth Amendment to counsel of choice cannot interfere with the fair and orderly administration of justice, of the court's authority to monitor and control the pace of litigation. Sorry, guys. Both federal and state courts have repeatedly made clear that the right to counsel cannot be manipulated so as to obstruct the orderly procedure in the courts or to interfere with the fair administration of justice. More case law. Supreme Court holding there is no absolute right to a particular counsel where there is contravailing public interest in the fair and orderly administration of justice. The fair and orderly administration of justice cannot be maintained when conflicted counsel or counsel with the potential of conflict cannot meet the standard of serving as constitutionally effective counsel. See Coker. Damn Coker. An institutional interest is protecting the truth-seeking function of the proceedings over which, by considering whether the defendant has effective assistance of counsel regardless of proffered waiver. Damn it. When are openings? Oh. Coker. Hey, Shiraz, sorry. Furthermore, the danger of conflict-free proceedings was not cured by Daniel Rashbaum's withdrawal prior to the selection of jury. Charles Adelson filed a notice indicating his non-waiver of any conflict of interest with Daniel Rashbaum. Robert A. Morris then filed a response in which he advised that third-party counsel had been retained to resolve any actual or potential conflict of interest. In a reply to this response, Charles Adelson objected to Morris or a third-party counsel cross-examining him. The Third District Court of Appeal, when reviewing the disqualification of counsel in Coker, damn Coker, disagreed with the proposition that an actual or potential conflict could be avoided by having substitute counsel conduct the cross-examination. The Coker court further explained, damn Coker, the conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. The potential for conflict would remain as would the appearance of impropriety. Absent judicial intervention at this point, delay to the fair and orderly administration of justice will be at risk for repeating itself. Without the establishment of a sufficient ethical wall and the fact that even third-party counsel cannot avoid the potential for conflict, the court cannot permit Robert A. Morris or Adam Commissar to remain as counsel or record. Nor will the court permit this unattainable situation to continue. Accordingly, for the above reasons, attorneys Robert A. Morris and Adam Commissar are disqualified from further representation of the defendant. Number 5. Against this backdrop, undersigned counsel believed that Mr. Rashbaum's conflict of interest also infected Appellate Adelson's trial. During the course of the representation of Adelson, undersigned counsel learned that Mr. Rashbaum represented Donna Adelson prior to the arrest of Appellant Adelson. Stated another way, Mr. stated it another way. Mr. Rashbaum's previously represented a co-conspirator in the same or substantially related matter. Oh, and he had an actual conflict. And there was a footnote. Reference to the documents included in the appendix to this motion will be made by the designation A, followed by the appropriate page number. So Charlie is basically saying right there that Rashbaum was involved with his mother in the same or substantially related matter. Oh. Actual conflict of interest during the course of his representation. Get the words out of your mouth. An appellate Adelson. Notably, Donna Adelson was listed by the state as a Category A witness in appellate Adelson's case, A25. Subsequently, Donna Adelson was listed as a defense witness for trial. Ultimately, Donna Adelson was not presented as a witness during appellate Adelson's trial because she was removed from the defense witness list days before trial was to begin. After the state sought to interview her, undersigned counsel assert that Donna Adelson's removal from the witness list was done in order to protect Adelson's interest, i.e., in not being interviewed by the state, and against appellate Adelson's interest, i.e., a witness that could have corroborated Adelson's testimony, was not called by Mr. Rashbaum. Hence, Mr. Rashbaum's representation of appellate Adelson at trial, after having previously represented Donna Adelson, constituted an actual conflict of interest, as explained by 11th Circuit Courts. Rule 41.9, entitled Conflict of Interest Former Client, states the following: a lawyer who has formally represented a client in a matter must not afterwards A, represent another person in the same or of appeals in Porter v. An attorney who cross-examines a former client inherently encounters divided loyalties. Given the recent finding by the trial court in Donna Adelson's case regarding Mr. Rashbaum engaging in a conflict representation falling short of the ethical obligations for members of the Florida Bar, appellant Adelson asserts that the same principle applies to Mr. Rashbaum representing of appellate Adelson at his trial, because attorney Rashbaum was operating under a conflict of interest based on duties owed to his former client, Donna Adelson, whose attorney-client relationship predated Adelson's. Oh, guys, this does not look good. Substantially related matters in which that person's interests are materially adverse to the interest of the former client unless the former client gives informed consent. B, use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has become generally known. Or C, reveal information relating to the representation, except as these rules would permit or require with respect to a client. Oh my God. They should point out what this related matter was. Documents supporting the statement set forth in the previous paragraphs are included in the appendix to the motion, and the document established the following. The murder of Dan Markel occurred in July 2014. In 2016, the probable cause affidavit naming Sigfredo Garcia, Luis Rivera, Catherine Emanuel Appellate Adelson, Donna Adelson as co-conspirators was released. In 2016, attorney Daniel Rashbaum was so there's the 2016. I knew it was 2016. Donna Adelson's attorney for purposes of the investigation into the murder of Mr. Markel as evidenced by his signature on the Adelson family statement. You fucking asshole. Oh my God. Probably the only signature that fucking idiot ever got was his own on a... Oh, can you look at that, guys? 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder of Mr. Markel, as evidenced by his signature on the Adelson family statements. Bloody hell. Oh, that's... In 2022, Appellant Adelson was charged with the murder by Mr. Markel. Mr. Rashbaum filed a notice of appearance on May 9th, 2022. Tennis girl, you're right. From the way the law sounds, he probably should have never represented either one of them. Oh, my God. It says right there. He has his signature on a statement for the whole family. Appellate Adelson did not validly waive the conflict of interest involving Mr. Rashbaum's representation of him at trial and Mr. Rashbaum's prior representation of Donna Adelson, who was listed as a witness by both the state and the defense. A review of the record on appeal establishes that the conflict waiver inquiry was not conducted by a trial court. State law, guys. In Lee versus State, this court articulated the requirements of a valid waiver of the right to conflict-free counsel. For a waiver of conflict-free counsel to be valid, the record must show that the defendant was aware of the conflict of interest and the defendant realized the conflict could affect. Oh my God. On September 22, 2023, Donna Adelson, Mr. Rashbaum's former client, was listed as a state witness for the appellant Adelson's trial. On September 22nd, 23, Donna Adelson, Mr. Rashbaum's former client, was listed as a witness for the defense for appellant Adelson. In October 2023, Mr. Rashbaum withdrew Donna Adelson from the defense witness list in appellant Adelson's case after a hearing in which the state sought to compel Donna Adelson's interview. In November 2023, appellant Adelson was tried and convicted while represented by Mr. Rashbaum. In November 2023, Donna Adelson was indicted and arrested for the murder of Mr. Markel. In the defense and the defendant knew of the right to obtain their counsel. Notably, in Lee, the court found that the defendant and defense counsel had an actual conflict of interest because the defense counsel had recently represented one of the state's witness. Defense counsel had an actual conflict of interest resulting from his own prior representation of a key witness against the defendant and the public defender's recent representation of that witness. Oh my God, guys. November 2023, recorded conversations leading to Donna Adelson's arrest. Donna Adelson, oh my God, this is even in there. Donna Adelson discussed she had received from Mr. Rashbaum regarding whether she would be able to leave the country undetected prior to being arrested for the murder of Mr. Markel. Look, we have to make a decision at some point. After speaking to Dan this morning and knowing what they're thinking up there, I don't know if we'll make it out in time. I really don't. Because Dan said you might do all of this, get to the airport, and they'll stop us. And that could happen. It could happen. I don't know, but it's worth a try. Oh my God, they even got a YouTube link. Jeez, Murphy and Joseph. Fucking Charlie is hanging his mom out to dry. He's hanging his mom out to dry. She's getting hung out wet and wrinkly. Woo-hoo. In December 2023, Appellate Adelson, represented by Mr. Rashbaum, was sentenced. January 2024, Rashbaum appeared as Donna Adelson's defense counsel for trial. September 2024, Adelson was subpoenaed as a witness for the state for Donna Adelson. September 2024, Mr. Rashbaum withdrew and/or was removed from Donna Adelson's case by the trial court on the eve of jury selection. No, it wasn't. It was on jury selection day on the basis of Mr. Rashbaum's conflict with Adelson. In October 2024, the trial court, on its own motion, removed the remaining defense counsel for Donna Adelson on the basis of Mr. Rashbaum's conflict of interest and the lack of sufficient ethical wall. Accordingly, in light of the foregoing, Appellate Adelson intends to file a motion in the trial court raising this conflict claim against Mr. Rashbaum, who represented Appellate Adelson at trial, while owing duties to his former client, alleged co-conspirator and listed witness Donna Adelson, to whom he continued to provide legal advice. Regarding her own involvement in the case while simultaneously representing Adelson, because Mr. Rashbaum's conflict of interest in Donna Adelson's case was just recently considered and ruled upon by the trial court, undersigned counsel submit that it would be in the interest of judicial economy, to allow the trial court the opportunity to immediately consider whether the same conflict infected Adelson's case. The trial court is uniquely situated to decide this issue, having previously presided over Adelson's trial and now presiding over Donna Adelson's trial. And because the trial court was recently apprised of the conflict issues involved with these lawyers and parties, Appellate Adelson therefore requests that the court to relinquish jurisdiction to the trial court for a reasonable period of time so that he can file a motion raising the conflict issue. Appellate Adelson respectfully suggests that it would be a more efficient use of judicial resources to address this matter immediately, because if the trial court grants the motion, the instant appeal will become moot. In State versus Menacee, the Florida Supreme Court considered the question of whether the pendency of a petition for writ of, not going to be able to say the word, in the Florida Supreme Court, arising from the affirmation of direct appeal of the judgment, the sentence deprives the trial court of jurisdiction. To consider a Florida Rule of Criminal Procedure motion to vacate filed after that word's not coming out of my mouth, petition has been filed in the Florida Supreme Court. The Florida Supreme Court held that the trial court was deprived of jurisdiction to rule as Menacee's motion to vacate while proceedings were pending in the Florida Supreme Court. Footnote: alternative, by allowing the trial court to consider this matter, it may allow this conflict issue to be also considered on direct appeal. However, certiorari. Thank you, Sherez. It wasn't coming out of my mouth. I'm sorry. However, I was just thinking the same, Jane. Thanks. No one here is sleeping well tonight. No, I'm sorry, Jane. I just seen it and I'm like, oh, here we go. However, the conclusion of the opinion, the Florida Supreme Court stated the following. Our holding, however, does not preclude defendants seeking an order from the appellate court to temporarily relinquish jurisdiction to the trial court for the purpose of filing and being heard on a motion to vacate prior to the appellate court's disposition of the case. This is the practice now utilized in the appellate courts in this state case law. The filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. The proceedings in the appellate court, I'm just going to bring this up here, may be nearing conclusion, and therefore the appellate court may not wish to relinquish jurisdiction at the time of the request, but it might prefer to proceed with the disposition of the cause. This is within the direction of the appellate court to decide. Whether the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis. This denial of the request to relinquish, however, is not a ruling on the merits of the motion to vacate and will not prevent a subsequent filing of a motion to vacate with the trial court at the conclusion of the proceedings in the appellate court. Number 11, the remedy suggest in Menacee was allowed by this court in Jefferson State. Jefferson versus State. In Jefferson, while the defendant's direct appeal was pending, the court entered an order temporarily relinquishing jurisdiction so that the defendant could pursue a Rule 3.850 motion. The court stated that the following procedure applies when such relinquish is granted. You know what? When we're done reading this, I'm going to put that link in, guys, to see where it takes us. Combs versus State authorizes relinquishment of jurisdiction to the trial court when counsel informs the appellate court of an honest belief that there is an issue as to ineffective assistance of counsel. The opinion, as well as State versus Menacee, appears to us to contemplate that the proper procedures to follow when such relinquishment is granted is to file a motion of post-conviction relief pursuant to Florida Rule of Criminal Procedures. If the trial court does not grant the relief, a new notice of appeal may be filed. The original appeal may proceed if there are other issues and should be dismissed if there are not. As our order in this case stated, jurisdiction was relinquished for collateral proceedings, i.e., for instituting proceedings separate from the trial and pending appeal. However, no such motion was filed. Instead, the trial court and the parties apparently relied on the allegations in appellant's motion to relinquish. While this procedure was not in technical compliance with our order, we entertain the appeal by treating the procedures below as having been conducted pursuant to remand for hearing upon an application for new trial. Oh my God. And that's Antone versus State, cited in Combs, in which the Supreme Court remanded for testimony in the trial court on application for new trial under Florida Rule of Criminal Procedures. Ineffective assistance of counsel may properly be raised as a ground for new trial, the issue in this case having been thoroughly aired before the trial. Court is not sufficiently preserved and presented for our review, and the appeal from the judgment of conviction is carried over for that purpose. Yeah, it is. If I read it correctly, he was Donna's lawyer first, so technically should not have been. Yeah, he was, and Charlie basically it's his words, obviously going to Ufferman, saying that Rashbaum represented Donna in this matter, and it's Rashbaum's signature on the Adelson's notice that they put out. What a slime bag. What a freaking slime bag. I hope he puts his head on his pillow tonight and he gets haunted by Dan Markel. A first for me, but I am not a legal beagle. I think this might be the first time I've seen a YouTube link in a criminal case court document. We will look back at it. We're almost there. We only got a few more pages, guys. See also Libby versus State. Accordingly, we affirm that trial court's denial of appellant's Rule 3.850 motion without prejudice to appellant. 1. Filing another such motion after his present appeal has been declined or decided and has become final. Or 2, as recognized in Menacee, seeking any order from this court to temporarily relinquish jurisdiction to the trial court for the purpose of being heard on his motion. Wright versus State. The Rule 3.850 proceeding was conducted in the trial court while the plenary appeal was pending, here pursuant to our express relinquishment of jurisdiction for that purpose. Number 12, more recently, this court court followed the relinquishment procedure set forth above in Ferguson versus State, as demonstrated by the court's December 30th, 2020 order in that case. Footnote, notably the trial court granted relief after this court relinquished jurisdiction, and therefore the direct appeal in this court was later voluntarily dismissed. And Wall versus State, as demonstrated by the court's December 22, 2016 order in the case. There's a lot of cases. Oh, this is solid. See also Houghton versus State, order granting motion to relinquish jurisdiction. Crane versus State, December 6, 2016, order granting motion for relinquish. Versus State, August 12th, order granting motion for relinquish. Oh, my goodness. 13, pursuant to Manus, Jefferson, Ferguson, and Libby, appellant Adelson requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict claim. Consideration of the factors set forth in Menacee and Jefferson establishes that the relinquishment is appropriate in the instant case, i.e. the current direct appeal proceedings are not nearing conclusion and the initial brief was not yet been filed. Appellant Adelson's conflict claim is not frivolous, and undersigned counsel have an honest belief that there is a credible and good faith basis of Appellant Adelson's claim. Moreover, Appellant Adelson submits that it serves both the interest of justice and judicial economy by having the trial court address Appellant Adelson's claim at this time, since the conflict claim was just considered by a trial court in Donna Adelson's case. Oh my God. Certificate of counsel, undersigned counsel have contacted opposing counsel, Chief Assistant Attorney General Tricia Meggs, who has indicated that the state needs additional time to consider its position. Undersigned counsel will file a supplement indicating that state's position, or the state will file a response. Wherefore, the reasons set forth above the appellant Adelson's request the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict of interest claim. Florida Rule of Appellate Procedure 9.600 states that if the jurisdiction of the lower tribunal has been divested by an appeal from a final order, the court by order may permit the lower tribunal to proceed with specifically stated matters during the pendency of the appeal. The rule is intended to prevent unnecessary delays in the resolution of disputes. Certificate of service. I hereby certify a true, correct copy of the foregoing. Assistant Attorney General Tricia Meggs. We got to get rid of the address, Michael Offerman's address, and that is it. Jeez, new trial, guys. That if that's not a big F you to Donna Adelson from Charlie Adelson, I don't know what is. Let's find that. Yep, I agree, X. That's a new trial. That's a new trial. Especially with the fact that that son of a bitch. I'm going to go back up. Actually conflicted at time of Charles. Yep. Let's go play. Oh. As soon as I read that whole part where he signed, let's see where it says. It was September. Let's find where it's got the. What a freaking douchebag. Now, he was completely in it for the money. Completely. This is inedible. I want to know what happens to Rashi. This is right, Shrez. This is disgusting. Right from the freaking beginning. I'm trying to. I got to find that. He's in the soup now. But we should take comfort in the fact that Adelson's rat seems to be turning on each other. Like I said, if anybody turns on anybody, it's going to be Charlie. But this is sad. I got to find that. Oh, there. In 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder. Right there. Charlie's obviously told them that. As evidenced by his signature on the Adelson family statement. He's still signing documents as her legal representation while he was defending her co-conspirator. This is wild. He knew better and did it anyway. This is disgusting. I gotta get to where that phone call, where he says about the phone call, because that's where. Oh, right here. Okay, guys, I gotta put this in to see what YouTube channel this takes us to. Give me 1 second. Be Says it can't be reached. This channel can't, or this website can't be reached. So let me see if I put that in. Does that help? Yeah, it says it can't be reached. Oh, wait. Just brings me to the main page. Let me go back to this. It just takes me to the main page, guys. Okay, let's see what I missed. Once again, everyone here thought they were the mastermind playing the other people. Freaking hilarious cluster. I think Donna could likely turn on Wendy too. Let's face it, friends, the whole thing is blowing up and it's everyone for themselves. Plus Wendy just hung them out to dry. That must be so mad at her. They must be. I still don't see Donna flipping on anybody. I really don't. The suspense, I wonder if one of the GG calls she posted, it might have been, because it's not, unless I typed it in wrong. Here, let me type it in here and see if it'll bring it up here. Let me just see if it'll bring it up or not. That's not the same as in there, though. I put it in there. Okay. Oh, you were able to get it in there? Let's see. Oh, it is. That one's Gigi's. That's Gigi's. That's Gigi's. A new trial for Charlie has to have Wendy shaken in her boots. She's a lawyer. She must know what that fact ultimately means as it relates to her. Charlie knows she hung him out to dry. Yeah, but if she keeps believing what the state has said one at a time, it actually gives her more time. Tennis girl is a rock star. Tennis girl is a rock star. Thank you, Tennis. I'm losing hope that Wendy will ever go. They link to Gigi's channel. Way to go, Gigi. Way to go, Gigi. Wait till it's great. They link to Gigi. That is awesome. Wonder if she knows yet. I think she does. Because I got an alert that she was going to be talking about this. I got it while we were talking about it. No haters going after Gigi now. She'd be a target. Man, and thanks for the mod, Cash. Moldy Cash. Gigi, you are a rock star. She is. Now haters, yep. Now haters are going after. Because who was the OG that got the phone calls in the beginning? Oh, man, God. Oh, what am I doing? I don't know what I'm doing. I'm so glad this dropped. Oh, I don't know. I'm wondering if I can put this into and put it on the community board for you guys. I'm still trying to figure out how to do the community board, guys. You know, it's a good thing that there are so many creators that know Adelsons are guilty AF to go after. You know, I agree with Carl Steinbeck. The one at a time approach not only hasn't worked, but it's cruel approach. And as it relates to the Markels, they shouldn't just arrest them all. I'm not, no, I'm not on mute. I'm not on mute. I'm not on mute. I'm not on mute. I know I'm trying to figure out how to do it to take a file. I know I probably have to transfer it to, I see apples and I'm like instantly got PTSD for apples. Jibs, well, this is not legit if the lawyer isn't using the real OG's channel. Crime and Coffee crew celebrate with a Mean Girls meltdown. That's me celebrating. Everyone has said one at a time is ridiculous. They're gonna like. A new trial's lost cost for Charlie given state's new evidence. He then must be looking for a plea. He knows, guys. Just think of it this way. He understands what he's looking for, what he's looking ahead to. None of the other Adelsons have been to a prison. He has. He understands what the rest of his life is going to look like. If he gets this opportunity, this is a plea deal opportunity. Because he knows what the rest of his life has in store. He's seen his future. He's already lived his future. There's nothing else for him. That's his future. And don't worry. It's contagious. Sorry about the apples, Rochelle. I thought you were muted. Turns out I paused you trying to copy the link. That's okay. It's a Crime and Coffee crew thing. If I mute myself or you guys, Jamie yells at me all the time. Meanwhile, it's her that muted herself. It's hilarious. Oh my goodness, the state is so flat-footed and the Adelsons have been so many steps ahead of state. No way they take deal. Why the state is completely inept and they know it's sorry, y'all, but this is beyond bad. It is beyond bad. But here's what, pardon me, guys, the medicine is kicking in. Here's the way I want to look at it. Tennyson, I'm hoping is they know now it's not frigging just egg salad on their face. Thanks to this. This is worse. This is rotten egg salad on their face. And the only way to clean this mess up, arrest them all and say, get one of them to flip. No more trips to Asia, Charlie, but he might be the first to get out of prison. The best thing the DA could do to save face here is at the time Charlie is granted a new trial, they should immediately arrest Wendy and Harvey. If they all want a deal, then go back to Katie. See if her memory is all good now. There must be someone pulling strings in Tallahassee. Swear to God that, or Wendy is an antichrist. I think she's antichrist. Now Donna will be anxious about what Charlie will do. Rochelle, I never yell at you, especially through cap locks. What if it is all an elaborate plan to take down the crime family? I like to think positive. Ooh, you got some strong Kool-Aid there, Sky Troop. I love you, but you got some strong Kool-Aid there. Does anyone here think the state will do anything any differently? I don't. I don't. Do I think they should? Absolutely. What we hate to admit that Wendy was right. Tallahassee is uncivilized. They're soft on crime. Good call, Wendy. We still despise you. I don't think Tallahassee's uncivilized. I think they just got a bunch of cracker jacks dealing with this case. Because remember, we got some great Tallahassee people. We got True Crime Wifey. We got Patty's Playhouse. Tally Gal. We got some real good people in Tallahassee. Stephen Webster, Tim Jansen. They just got some crackerjack people running the show. I quietly complain in phone calls. They all needed to listen to Carl. He has it figured out, Gamma. The man has not been wrong. Oh, Tallahassee, justice is uncivilized. Yeah, it's not justice. That's not justice. Can you imagine Ruth and Phil reading this right now on somebody's channel or sitting in their living room reading this right now? Shame on them. Shame on the state. I think they underestimated the length of the Adelson's reach. I don't think it's so much the reach, Irene. I think they underestimated their noggins. And what they didn't realize is Charlie was going to get around a bunch of people that would wake him up to his sister. Seriously, if all the Adelsons want to talk, I think they should give the deal to Katie. That would totally stick in the Adelsons. Nothing major. Parole after 25 or 30 years. Yep. How many people, you think Katie 25 or 30? Why not give her the same deal that they gave Rivera? Give her the same deal they gave Rivera. They were going to let her walk free. Or give her the same damn deal again. Third time's the charm, people. I would rather see Katie out than any damn Adelson. They were going to offer it twice. They offered it twice. Go knocking on her door. Find out if she's going to take the deal. Then go and fucking round them up. That's what I say. Do you hear me, Jack Campbell? Do you hear me, Sarah or Georgia? Sarah Catherine Dugan? I could live with a Rivera deal if it means the Adelsons stay in prison for life. Yep. They have offered her so many times that she doesn't come out with anything. If she had told it all at Charlie's, I think they would have cut time, but she's holding back. They offered her a get out of jail free card. I'm wondering if there's a fear, because all the Adelsons are still out there, and I think the fear belongs in Wendy's corner for her. I don't know why. I just feel that. I'm wondering if they were to offer her that same deal today and guaranteed that all the Adelsons would be rounded up prior to her getting out, prior to her deal getting out, would she take it? No. He got 19 years. No, not a walk, but fairly short sentence, and most ran concurrent with a Fed charge he had unrelated to the Markels. Yeah, so Jack Campbell, now you better find your balls, man. Find your balls. Because this right here is disgusting. Unbelievable. Like this line right here. This is enough for me. As soon as I read, where was it? As soon as I read this section, Gamma says, Rochelle, I think they have threatened Katie with harming her kids or family members, and she's afraid to say what she knows. And I think it comes from Wendy's side. I honestly do think it comes from Wendy's side. I think Katie knows that Wendy is the mastermind, and she's afraid of Wendy. And I think if Wendy was in jail, she wouldn't be afraid no more. And she would remember everything. Like, in my opinion, she was only protecting one person. Don't ask how I know, but today it would take legal maneuvers to change her sentence. She was only protecting, you think she was only protecting Sigfredo? Katie could still be guilty, but they could say time served and let her go for her testimony. If the Adelsons want to plead, Katie's credibility instantly is restored. They are not a threat to her. Well, there's some kind of money situation with the Adelsons and Katie. We know that because it was coming out in Donna's trial, because all Katie's lawyers were wrapped up in it. So we know there is a money trail of some sort to Katie or Katie's family. So we know that for a fact, because even Katie's brother was going to be a witness. But this one right here, in 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder. That son of a bitch. Of Mr. Markel, as evidenced by his signature on the Adelson family statement. Did it not have exhibits? Did we not get those? Because it's A22? A22. Do we not? I wonder if they have that in there yet or not. Katie could also argue she received inadequate counsel because her attorney was paid for by the Adelsons. She might get a new trial. Absolutely, she was protecting Sigfredo. And as I have told you, there is a money trail, but if they're all gone, she's fine. Exactly, and that's what I'm saying. If they can promise her safety, if they have this evidence and they can promise her safety and her family's safety, well, she might just remember everything. I gotta see, guys, if there is I just noticed, and I closed the friggin' thing up. I'm just going to double check again, guys, just to make sure I didn't miss any of these, because it's A22. Thing is, no crimes, saying stuff like that in when everybody is so deep into the Adelsons and not being able to share the information, that is a hard pill to swallow for people. Let me see. Appendix. Order motion to extension of time. Okay. Oh, here we go. Here we go. I'm going in there right now. Appendix. Holy Jesus, there's 105 pages to the appendix. Why is it? It's going to take a bit. Here, we'll get rid of this right now. Come on. View. It's loading. We're looking for A22. Oh, did I get rid of the wrong page? Oh, we can get rid of Leon County Court. We don't need that. Okay, here we go. I'll share this, guys. This here, guys, is the Windows. This one. This is 105 pages long, this one. And the content creator that claims to have known. And the content creator that claims to have known all this, well, why didn't he send all this case law to states? Yeah. Or the content creators that have all these people, they should have been right on top of the fact that this was an issue. Okay, let me see. Let's get past the addresses. Holy geez. So we're looking for A22, A21. There's no A22. What are you talking about? I think FF made it into. Oh no. Okay, that's the Tallahassee Democrat. Adelson Markel accusations, fanciful fictions. Do you guys want me to show you how to get this information? Do you want me to quickly show you how? I'm disappointed with the OG too. I am. Should have been on this shit. Okay. So I've got it up here. So let me just walk you through it. I'm not going to close that one, but I'll do this. I'm going to walk you through it, and then, because this is 105 pages, guys, and I don't want to read all 105 pages because I'm not feeling well. So share screen. Okay, let me take myself out of it for a second. So you're going to go to appeals court case search. Let me see if I can link this page. Or I'll just copy this here. So you're going to first go to walk us through it. What is going on now? My phone's. Why is it doing that? So you go to Florida Appeals Court Search. And then you're going to go here to Florida Appellate Case Information System. Night X. Yeah, we're soon. And you're going to go here. Let me see if I can. I'm going to post this link here, guys. I'm going to post this link. That's the link you go to. Oh, I got to share this page so you can see it. Hello, Louise. How are you, my dear? One sec. I'm going to show you the next one. My computer's like, come on, you're feeding me too much. Oh, I think I'm froze. Yep. I think I froze up. Am I still frozen, guys? No, okay. Okay, there we go. So on this page, guys, you scroll all the way down to search. Once you get in that link, you go to search records. Then you're going to go to party search. Right in the name, you're going to put Charles Adelson. And then you're going to scroll down and go to search again. And it's going to be the first one, Charles Adelson versus State of Florida. And here's all the appellate information right in here. So the one that is 105 pages is 10/16/24 record appendix to motion to relinquish. You just click on that and then you get what we've got right here. And this is his probable cause, summary of offense of probable cause affidavit. This is everything about why they were arresting him or why they think he's guilty. Oh, Louise, you're such a sweetheart. Thank you so much. Thank you so much for your support, Louise. Change children's names, the suspect vehicle, everything about what happened the day of the crime. Oh, are you still not feeling well, Louise? Hopefully you kick that soon. And then, Jesus, there are 105 pages, guys. It's a damn novel. About phone calls. Daniel Markel contacts Wendy Adelson for 1 minute. Video shows Markel arrives at premiere. I think this is going to be like all kinds. Is there going to be text messages in here? Sell your telephone information. Evidence of purchasing following homicide. Of the purchase, McBanawas finances. Ooh, this is a good find, guys. Oh, geez. I'm not... What a dodo brain I am. Share screen. I am so... What a dodo brain I am. I'm going through it thinking you're following along. A22, I think it's connected to A21. Because it talks about... where's A21? It's section 2. The index at the beginning acts as a table of content. The exhibit I was looking for isn't there. I wanted to see A22. Same did I, but I'm thinking A21 is connected to exhibit 2 because it talks about it's showing, because the fanciful fiction was that statement put out by the Adelsons. And I think that's why I think it's attached to A22. He was brilliant, tennis girl. He was brilliant. If you think about it, he needed Rashbaum in Donna's trial to be dismissed. If you think about it, this was a brilliant move on Ufferman. He delayed, as you can see in the appellate thing, he kept asking for remand or extra time. This was an absolute brilliant move on Ufferman. He needed the trial court to get rid of Rashbaum. It works in Charlie's favor. So it was a big, huge thing. Rashbaum derailed a whole trial because he was conflicted. Oh, I hope you get better, Louise. We all knew it was a bombshell. We just didn't really... or grenade. We just didn't realize how big of a grenade it was until now. And this was planned. This was Charlie and Ufferman sitting there watching the calendar, counting the minutes. Oh my God, this was planned. So I'm going to see, where is exhibit 2? I wish it would take, A2. I wish it would say, yeah, that's A3. Let me see what 20. He didn't need Rashi to resign. He said the conflict existed before Charlie was arrested, and he's right. No, he's right, but it just cements it more, Tennis Girl. It just shows how conflicted, and that Rashbaum didn't care about the conflicts to even go as far as he did with Donna. It just makes it a stronger argument. There are so many possible reasons for the delay of Offerman's part. I'm holding off judgment for now. He's not the kind of lawyer that likes to muck up the court system with dirty tricks. I don't think so. I think the man's brilliant. I'm giving him credit for this. Like this, if this is brilliant. If anything, the man can say he saved Donna from going down the same path. I think this is a brilliant move on Offerman's part. Unfortunately, it's for Charlie Adelson's benefit, but conflicted, yes, but he messed it up because he is grade A ass. It may be good lawyering, but it's morally reprehensible to push like this, cost the state money, Markel's time, and emotional pain. Like I actually have no bad words whatsoever to say about Offerman. I'm like, if he could, who knows? Maybe Charlie didn't tell him till the last minute either. Maybe Charlie didn't give him this information. Oh, poor Louise. Oh, my dear. I do thank you for your support, but I wish you would get some rest. You got to get rest, my dear. But you are very generous to me, and I appreciate you so much. Laugh out loud. I'm giving him credit for being unethical. I'm mad all over again. Yeah, and I agree with Shiraz. Like, Offerman is a very good, and he's highly respected. I'm not saying anything bad. I'm saying, way to go, Offerman. If you were able to do this for a client that doesn't even have the right, my God, what's he going to do for Wade Wilson? What could that man do for Wade Wilson if he can do this for Charlie Adelson? Like, this is, I want to get down further because I want to see what extra stuff they've got in here. Calls, Donna and Charlie discuss meeting and whether or not Charlie needed to bring cash. Charlie inquired whether or not a threat was involved and whether the police should be contained. Donna. All the calls are in here, guys. I sleep and rest at choose. Some awesome you are still here. Not for much longer, my dear, but we will be for a bit. Charlie never contacts any other female to discuss the contact between his mother and undercover. Here's the restaurant with Charlie. Holy crap, this is a fountain of information. If it's the police, they can't take the money and won't even come meet you. They fucked up. If it's this guy, maybe that's what he knows. You better kill him because he's going to be a big problem. If you can't do it, it will have someone else do it. Holy. Magbano and Garcia continued to argue over the next 2 days. She packed some of her belongings in her car and left on April 23rd, 2016, in the middle of the day. Magbano tells Charlie later in the day that she left the house and left her kids with their father. Wow, that's A15. I want to get down to A22. KM calls. The one juror had to leave because he tested positive for COVID, but that's the only one so far. But they have 9, Luis, they have 8 extra jurors, so 19, 20, 21, A22, right there, A22. On behalf of the Adelson's family, we continue to send our deepest condolences to the Markel family. Disgusting. Dan's death was a tragedy and the loss is profound. Although Wendy and Dan were divorced, he was the father of their 2 children who must now grow up without their dad. Can you guys see this? I hope so. There has been a lot of unsupported speculation that the Adelson had something to do with the murder. This speculation is categorically false. To be clear, none of the Adelsons, Wendy, her brother Charlie, or their parents Donna and Harvey had anything to do with Dan's murder. We respect the process of the enormous amount of work that the Tallahassee Police Department has done in this case. They have spent the last 2 years reviewing every shred of evidence out there. He made to the media not a signed document, but it said it's see our full coverage of Dan Markel case. Oh, maybe the signed document is closed, maybe. Who knows? Because there is a signed judge's signature. Maybe they didn't put it in here, Shiraz. Maybe they didn't put it in. Because they do state it. Where is it? Did I close it out? Hold on. Okay, here we go. I'm going back to it, Shiraz, just to see. Oh, it says, hold on, let me go back to it. In 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder of Mr. Markel, as evidenced by his signature on the Adelson family statement. A22 is what it says. So maybe they left that document out because it was going to be public knowledge. Well, hold on. What if we pull up? Oh, that sucks. I don't have the Tallahassee. I don't pay for it. Might have to start paying for that. No, Charlie had representation with David Oscar Marcus until he was arrested and then went with Rashbaum. No, I don't think it says A22. Adelson family statement. They must have left, unless, let me go into the case here and see if there's something else. Appendix to motion to relinquish. That was, 10/16. Irene, so Donna and Wendy got. Oh, you're welcome. So we need to get our hands on, is an important point, is he spoke on their behalf as far back as, Shiraz, this is insane. Oh, there's transcripts. Unredacted, not fully redacted. 2,169. Oh, record of appeal. Guys, look at what this is. This is on behalf of the family. Don't worry about it. I misunderstood what the document meant by signed statement. Look at this, guys. Look at this. This is a fountain of freaking information right here. I can't make this any bigger, but down right here, 5/20/24, record on appeal, unredacted, not fully redacted, record of appeal. It's all the bloody documents not available. They may not be public record. Oh, you buggers. Contact the clerk of public information officer in the court where the case is filed. Haha. I will do so tomorrow. And then there's another one. 05/20, transcript, unredacted, not fully redacted. Is that one? No, got to call the clerk of courts for that. Okay. Hi, Ty. Hello, good evening. I just wanted to thank you for being so nice that day. I don't know anything about this case, but I'm grateful anyway, and all of the best to you. Kisses from Brazil. Let me just do this. I gotta. And I remember right, it was Portuguese Brazil. You're very welcome, Ty. Quite the amount. Notice of agreement extension, motion to supplement record, order of motion, clerk Leon. Redacted 12 pages. Is that going to open? No. Okay. So anything that says clerk Leon, you've got to go to them. Well, guys, we started out with Charlie. Then we went to Boone, and we end with Charlie. That's how it works on Crime and Coffee. goodness. This is, I wonder what the last page says. Adelson certificate of service. Oh, it's just talking again about Donna's case being canceled. A lot of state law, Oh. Well, I'm really interested in what Carl's going to say about this. What is this? State of Florida, County of Leon. I, Janice W. Booth, registered merit reporter, do hereby certify that the foregoing proceedings were taken before me at the time. Oh, okay, that's the court reporter. That's the court reporter. That's all about Donna. All about Donna. My goodness, guys. I mean, I understand a little English, but very little. Yeah, and I was trying to help out with doing a translator the other night. Okay, guys. I need to get some sleep. I guess we'll discuss this more tomorrow. Oh gosh. Oh. Ty, your English is perfect. Glad to have you. See you soon, Louise. Get some rest, my dear. Don't worry about me. You can understand. Oh, I will make sure you can too, though. That's what we do here. Oh, what a night. All right, guys, I am going to sign off. I greatly appreciate every single one of yous. And I will see you tomorrow night. Thank you for being here with me. Looks like everybody else must have left. And Armand's still here. Good night, my friend. Good night, everyone. Talk to you soon. Take care.